Hello, chat. Hope everybody had a wonderful holiday. Just so you guys know what we're going to be talking about today, we are continuing our motions reading for whatever was available on the docket for Zachary Adams' petition for post-conviction relief. So last stream, we made it all the way through the end of the 2024 filings, although we did not take a deep dive into this Exhibit A, where we have all of Jennifer Thompson's billable hours line items chronologically, which I do want to take a look at that if we have time at some point between now and the hearing, which is going to be this Monday and Tuesday. So this is pinned for later because it's like 300 pages. But today we're going to be starting the 2025 documents. I'm going to try to get us through, we'll absolutely get through February. And I'd like to try to get through March, but there is a lot. There is a lot going on in March. So that's the optimistic goal. So we'll go to My Voice Hurts and we'll either get back together tomorrow or I might do a shorter stream tonight to look at some civil forfeiture issues in 2010 in this very same judicial district. So District Attorney Hansel McAdams, you might remember that name. That was a district attorney dealing with the Holly Bobo case before Matt Stowe took over. Yeah, he was driving around a BMW that was seized through civil forfeiture, and this audit report was for the year 2010. Remember, Holly's abduction happened in 2011. So, and it's not just Hansel McAdams, it's not just a BMW. There were many hands all across a bunch of different case files. Not a good climate in 2010, and I would presume it didn't magically get better in 2011. So there's a chance that tonight we might do a shorter stream reading through that audit. It's 28 pages. If not, we'll squeeze it in tomorrow or Sunday. But I'm excited. We've come a long way. This has been a month-long deep dive into this case. It's disgusting, the stuff that we're seeing. It doesn't seem like it gets better any day that we look at it, except that we're seeing some great advocacy. And we know that what we're looking at here around the time of January, this is going to be the first document that we look at. You know, it's crunch time. They have these evidentiary hearings set, which I'm sure the state was shocked that hearings were even set. They probably expected dismissal without a hearing. And this is really the runway ramp to where we're going to be this week watching these hearings, the final hearings. Also, big shout out. Nancy came in with a thank you super sticker. Thank you right back. And also I saw this message wishing everybody an awesome Christmas. Nancy says she's excited to be on a live, usually replay crew. We love replay crew too. And thanks for all the content on this case. Well, thanks for watching it. And again, the way I'm going through most of this, almost everything that I've deep dived on this case, I've tried to bring into a stream, whether I'm watching it live or reading it live for the first time with you guys, or I'm seeing it offhand and I'm trying to summarize it for you guys because maybe it's, 300 pages long. But love that you guys are here watching this all unfold with me. Hey to Jimmy, hey to J Money, hey to Jersey Girl Trey. We got all the J names in a row. Good to see you guys. Hope everyone's doing well. YSL Kells is here. Phoenix Rising is ready for the live hearing. So we're just doing motions readings today. The hearing will start, I'm assuming, probably 9 a.m. on Monday. I'm going to be live all day. Those are going to be 12-hour streams. We're going to have guests popping in and out. Just to forewarn you, we might have some guests popping in that aren't familiar with streaming. So in advance, I'll try to set etiquette hey, let's let the court play. But if we do need to pause to talk about anything, just know we'll do what we always do. We skip the lunch breaks and we'll get caught up. But I think you guys will love the guests. Just know that they might be new to StreamYard and YouTube live streaming. Good morning to DB. Good morning to DB. We've got Aaron in the building. We got to get the rest of the Aarons in here, get the whole gang going. Lexi's here. Lady L. We got the L names together here. Ariel. Michelle, good to see you. It's funny because Ariel and Michelle both have the sound of an L in their name. And Factual Lie is here. And we also have J Money gifting very generously 5 gifted subs here. So big thank you here to J Money. Good to see you. Thank you so much for all your support this year. And thanks for becoming a friend through these YouTube streets. We got KLBOG in the building and a Law Nerd Amber. Guys, let me get to reading. If I need to stop for like a drink to save my voice, I might throw on some Jason Autry for us. But other than that, we're getting right into it. So we've got this motion to dismiss the post-conviction claims. So this is the state saying, get rid of it all. Throw it away. Throw it away. The state, we want you to dismiss all the specific claims raised in Petitioner Zachary Adams' second amended petition for post-conviction relief. That's the most recent amendment that we read on the last stream, in which the facts alleged fail to establish that the claims for relief have not been previously determined or waived. For cause, the state would show as follows. So they're citing here Tennessee Code Annotated 40-30-108C. A district attorney general has the option to assert by a motion to dismiss that a post-conviction relief claim is barred. So state is required to file this answer within 30 days of the filing of the amended petition, or the notice that an amended petition will not be filed, unless the time is extended for good cause. Rather than file an answer, the state has an option of asserting by way of a motion to dismiss that 1, the petition is barred by the statute of limitations, 2, the petition was not filed in the court of conviction, 3, the petition asserts a claim for relief from judgments entered in separate trials or proceedings, 4, a direct appeal or post-conviction petition attacking the same conviction is currently pending in the trial or appellate courts. We know that an appeal closed out. I think it was like September 2022 that came down. The facts alleged fail to show that the petitioner is entitled to relief. Or 6, the facts alleged fail to show that the claims for relief have not been waived or previously determined. So if a post-conviction court determines that a colorable claim is not asserted by the petition, the court shall, and they're emphasizing that, enter an order dismissing the petition or an order requiring that the petition be amended. Next, they're going to their next argument that all coram nobis claims raised by Petitioner Adams' second amended petition for post-conviction relief are now barred as 1, previously determined, and or 2, on res judicata grounds. So they're going to say, back to the court's own order, on September 10th, 2024, this court dismissed Petitioner Adams' writ of error coram nobis. And that confused me that day when we were reading it, because it was written as order dismissing writ of error coram nobis and dismissing petition. And when we read that day, I thought it meant it was dismissing the whole thing, including the non-writ of error coram nobis petition for post-conviction relief. But that was just dismissing the writ of error coram nobis. So if you guys remember me being like, wait, so how did we keep going? That was only for the writ of error coram nobis. From that dismissal date, Petitioner Adams had 30 days to file a notice of appeal with the Tennessee Court of Criminal Appeals. No appeal was filed within the requisite period by Petitioner Adams, meaning this court's September 10th order is now a final order. This fact is important to highlight, considering Petitioner Adams is now attempting to relitigate fully adjudicated coram nobis claims and issues in a second amended petition for post-conviction relief. Specifically, the following paragraphs in Petitioner Adams' second amended petition for post-conviction relief contain coram nobis claims. So they cite 17, 19, 35, 36, 37. And then they also add that the claims previously determined by coram nobis court. And they keep switching how they spell it. I don't know why they do that. They keep going from the A to the U. In post-conviction relief proceedings, a ground for relief has been previously determined when a court of competent jurisdiction has ruled on the merits after a full and fair hearing. A full and fair hearing has occurred where the petitioner is afforded the opportunity to call witnesses and otherwise present evidence, regardless of whether the petitioner actually introduced any evidence. Issues that have been previously determined may not be relitigated in a post-conviction petition. Now, what I think is interesting is, like, a lot of the issue was the statute of limitations, which it's not quite the same as getting into the merits of an argument. On June 14th, 2024, this court held a full hearing on the state of Tennessee's motion to dismiss the petition for writ of error coram nobis. And I think this is where we might have that clip. I got to double check, but I think that's where we have that picture where it's like a full gallery on the one side and then Doug Bates and one guy in the gallery behind him, and it's just like really sparse looking. But I think that might have been that hearing. So this court had a full hearing on the motion to dismiss the coram nobis, with both parties allowed the opportunity to present evidence on whether or not this court should equitably toll the statute of limitations concerning Adams' coram nobis claims. Moreover, this court afforded both parties multiple opportunities after this hearing to submit supplemental briefs before ruling. As of September 10th, all of Petitioner Adams' coram nobis claims were adjudicated by this court on the merits and dismissed. Petitioner Adams cannot relitigate previously determined coram nobis claims by simply repackaging them as post-conviction claims. All coram nobis claims, second amended petition for post-conviction relief, should be barred and dismissed pursuant to Tennessee Code Annotated 40-30-106F. So they're saying everything was adjudicated on the merits and dismissed. Now they got res judicata grounds. So alternatively, this court should find that Petitioner Adams is barred from relitigating any coram nobis claims on res judicata grounds. Res judicata is a claim preclusion doctrine that promotes finality in litigation. The judicial doctrine precludes a second suit between the same parties or their privies on the same cause of action with respect to all the issues which were or could have been litigated in the former suit. In order for the doctrine to apply, the prior judgment must conclude the rights of the parties on the merits. Parties asserting a res judicata claim defense must demonstrate that a court of competent jurisdiction rendered the prior judgment, that the prior judgment was final on the merits, that both proceedings involve the same parties or their privies, and that both proceedings involve the same cause of action. So they're going to go through some case law here. And as applied here, all requirements set forth. Under Young, they're saying we've met all of the criteria. Harding County Circuit Court, being a court of competent jurisdiction for coram nobis matters, handled Petitioner Adams' petition for coram nobis and entered a judgment on September 10, 2024. Adams didn't appeal that. And let's see, the order became final on October 11th, 2024. Both proceedings involve the same parties. And lastly, both proceedings involve coram nobis issues/claims. So as such, the state of Tennessee requests that this court find that res judicata bars Petitioner Adams from relitigating those claims in this post-conviction proceeding. All right, so before we get to that, I see some new faces rolling in. Hey to Candace. Good to see you, Candace. Hey, Katie. Hey, Miss Kels. I think we have a Kels gang starting in the chat, too. We're up to 2 Kels in the building. Hey, Christine. Hey to Docket Decoder. Good to see you. Hope your drive to Florida went smoothly. No traffic. Hoping for the best. Sometimes the traffic between, like when I drive from here to Georgia or back, it can be the difference between like a 7-hour trip and then a 12-hour trip if there's construction and accidents, and just like that, your time can be doubled. So hope that drive went well. Good to see you. And this next argument, you guys, is that all new evidence claims raised by Zach Adams facially cannot satisfy the Dellinger standard. So if you remember the second amended complaint or petition, Doug was citing the Dellinger standard. So now they're going to counter that argument. They say a petitioner may raise a claim of actual innocence based on new scientific evidence in the petition for post-conviction relief. Claims of actual innocence that are not based on newly discovered scientific evidence are not cognizable in a petition for post-conviction relief. Bunch of cases. And then they cite those same paragraphs, it looks like. It looks like they're skipping paragraph 19. Here, Petitioner Adams' claims of actual innocence pursuant to Dellinger are not based on newly discovered scientific evidence, but instead on his own self-serving alibi. Well, I mean, isn't an alibi inherently self-serving? But okay, this just seems like they're like annoyed. Like you can feel their annoyance by the way they're wording this. His own self-serving alibi. Yeah, by definition. The alleged unsworn statements of a former security manager at Community South Bank. Oh, well, that's funny because this same former security manager, the alleged unsworn statements of a former security manager at Community South Bank This is the same manager that they run and go and grab this DVD device, and they bring a subpoena to him that says, hey, don't tell anybody else that we brought you this investigative subpoena. Don't talk about this. So just interesting that they would go out of their way to put in parentheses here, the alleged unsworn statements, almost like they're discrediting, like that they've never sought out or spoken to this person themselves when they ran out of their way to get first dibs once they heard the defense was speaking to them. Just disgusting. And they say the conclusory assertions regarding ATM data that lack any evidentiary support. These claims, I need a basket of tomatoes. These claims spatially are not based on newly discovered scientific evidence, and Petitioner Adams is not entitled to post-conviction relief on any substantive Dellinger set forth above. As such, each alleged Dellinger claim should be dismissed by this court. So 4 substantive constitutional claims raised by Petitioner Adams' second amended petition are barred on waiver grounds. Now, this is interesting because Doug went out of his way, we talked about this last stream, that every time we're raising an issue, we're like tacking on the parallel issue of, hey, if you're going to say we've waived this issue by not making an issue of it previously, then we want to raise an ineffective assistance of counsel issue for the first time. Because we didn't know about this thing, and if the state somehow wants to say that counsel should have known about this thing at trial, well, then we want to flip that. This is the first time we'd be aware that it would have been ineffective assistance of counsel. So, similar to claims that have been previously determined, Tennessee Code Annotated 40-30-1063G seeks to prevent post-conviction proceedings from being used as a substitute for direct review and appeal. So, essentially, a defendant may not withhold constitutional claims at trial for later litigation in post-conviction proceedings. There is and that's reminding me of Brian Steele. So, do you guys remember when we watched Brian Steele's, it was one of the Georgia Supreme Court oral arguments about general demur. And Brian Steele was not the trial counsel. But there was an issue with the indictment. The indictment was flawed. And Brian Steele's appeal argument was not just the issue with the indictment, but when asked, the panel wanted to ask Brian Steele, wouldn't that have been something that the trial attorney should have brought up right away? And Brian Steele smirks and he says, I think it would have been ineffective assistance of counsel to bring it up right away before the jury was sat. Basically, Brian Steele was saying, well, you want the jury to be sat, that way double jeopardy would attach, and then you raise an issue with the indictment. So, just a little sidebar there, thinking of Brian Steele. But here it says that essentially a defendant may not withhold constitutional claims at trial for later litigation in post-conviction proceedings. There is a rebuttable presumption that a ground for relief not raised before a court of competent jurisdiction in which the ground could have been presented is waived. Our procedure does not permit one to the practice of deliberately withholding the timely assertion of his constitutional rights upon his trial, to save them back for post-conviction attack in the event of a conviction. Furthermore, it appears clear that the legislature intended to restrict somewhat the ability of convicted criminals to collaterally attack their convictions, and to a large extent, the availability and extent of post-conviction remedies lie within the discretion of the legislature. A ground for relief is deemed waived if the petitioner personally or through an attorney failed to present it for determination in any proceeding before a court of competent jurisdiction in which the ground could have been presented, unless 1, the claim is based on a constitutional right that was not recognized as existing at the time of the trial and is to be applied retroactively, or 2, the failure to present the claim was the result of state action that violates the federal or state constitution. And then they cite here from the code that a ground for relief is previously determined if a court of competent jurisdiction has ruled on the merits after a full and fair hearing. Now, I think one of these claims relates to Adams' decision not to take the stand. So I think that's one of them. But a lot of, you're relying on a court of competent jurisdiction, But during these evidentiary hearings down the road, once we have Jerry Gonzalez on the stand, we're going to hear that the court was standing in the hallway with a gun on his holster as the defendant walked in and out every day, and he was being urged to just take a plea. And then his counsel was saying, you shouldn't testify. Don't testify. You can't testify. It'll be the worst. Where was I? Let's see. All right. In determining whether a claim contained in a petition for post-conviction relief should be dismissed without a hearing, the post-conviction court should review the petition to determine whether the petition asserts a colorable claim. And this would be the dream, not just because it's an easy win, right? Dismisses without a hearing. But I think these hearings are what put a huge spotlight on the troubling context surrounding the conviction of Zachary Adams. Because so far with the docket, they've been able to keep whatever they don't want the public reading. They just describe it really vaguely, or they asked to put it under seal. At this point in time, I don't think there were eyes on this. So if you can get it dismissed without a hearing, not only is that a quick victory, a swift victory, but it keeps the lid on what happened. There's no transparency. They define a colorable claim as a claim that, if taken as true, in the light most favorable to the petitioner, would entitle the petitioner to relief under the Post-Conviction Procedure Act. If the facts alleged taken as true fail to show that the petitioner is entitled to relief, or in other words, fail to state a colorable claim, the petition shall be dismissed. All right, and they cite where the petition has standalone constitutional claims: 38, 39, 41, 42, 44, 45. Here, Petitioner Adams could have properly presented these standalone claims to the original trial court because they existed at the time. Could you, though, when the initial trial court was standing in the hallway with his gun while you walked by, saying things like, I would have been running down to the courthouse, I would have been the first one running to take a plea. So we've got Petitioner Adams could have properly addressed these at the trial court. Petitioner Adams also could have properly sought relief on appeal, but he failed to do so. And Jennifer Thompson was his appellate counsel, so we didn't raise any ineffective assistance of counsel claims because we have the same counsel. So I would argue there's novel issues that have not been addressed by a court. As such, these standalone constitutional claims appear to be waived, and this court should summarily dismiss these claims. They cite here, we've got McNair v. State, finding that petitioner waived any freestanding claim regarding the composition of the petit jury by failing to present it in a proceeding before a court of competent jurisdiction in which the ground could have been presented. I mean, first of all, that's vague, but I don't think that's applicable. I think they're dancing around the issue here. Like, that's very different than raising the issue of competent counsel. And if I'm not mistaken, wasn't there a point where Zach Adams, maybe it was post-conviction, where I know he went pro se. He first filed this petition pro se. Wasn't there a point where he wanted to withdraw counsel? And he wanted to bring Luke Evans on? Like, there's issues here with waiver. And I don't think saying that, hey, here's a case where maybe somebody didn't exercise all of their strikes or raise a Batson challenge about the exclusion or failure to strike a juror. I don't really think that's a comparable issue. Then they cite another case, finding that petitioner waived a freestanding claim regarding inappropriate closing argument by failing to present this ground on direct appeal. Well, guess what? We watched the trial, and guess what we heard Jennifer Thompson saying during closing arguments? Your Honor, I can't hear what she's saying. And then the court thought it was no big deal. They made no effort to make a change. So you had Zachary Adams' trial counsel say, we cannot even hear what Jennifer Nichols is saying in her closing argument. Well, how can you object? How can you object if you can't hear what's being said? And what are you to do with it if you told the court that you can't hear? Petitioner Adams has waived these remaining standalone claims due to his failure to raise them at trial or on direct appeal. Therefore, and you notice they didn't go one by one with the issues. They just gave a lump of paragraphs and then a broad brushstroke argument here. So that's their argument. And then in conclusion, for these reasons, the state respects the court dismiss all of these claims, finding that they've been previously determined and failed to satisfy Dellinger and or were waived. And that's Amy Wyrick. Chris Boiano. All right, so that was January 8th. On January 9th, we have a motion to allow the state of Tennessee to inspect all documents and exhibits filed under seal. This might be some stuff that came through from the appeals court. So they're saying that, you know, they want this access on the basis that Zachary Adams alleges ineffective assistance of his attorneys, rendering any and all work done by counsels during trial and in preparation for trial relevant to disprove petitioner's allegations. So they want all of the work product. The state has a duty to diligently prepare for the hearing in this case and protect the conviction. Information contained in the documents currently under seal in the circuit court clerk's office should be accessible to the state in its preparation. Allegations made by petitioner in pending post-convictions may be refutable or called into question by the contents of documents currently under seal, and the petitioner's counsel has had an opportunity to view the documents under seal. So for the foregoing reasons, we ask this honorable court to allow the state to inspect all documents placed under seal during the prosecution of Zachary Adams. January 13th, we have petitioner's response to the state's motion to dismiss portions of the post-conviction relief. So let's see the response here. And is it just Doug Bates? Because I'm wondering when we have Claire come on. All right, Crystal. I keep calling her Claire. So we have Crystal on board now for these filings. So Doug Bates and Crystal. And we've got, comes now the defendant/petitioner is responding to this motion to dismiss. The defense will attach the three-pronged approach in the order in which the state has presented such claims. So they're going to go 1, 2, 3, just like the state did. First argument was that the coram nobis claims, spelled correctly, do not bar previously determined claims and or are barred on res judicata grounds. The state attacks the following claims for relief on the basis that said claims were previously determined by this court's September 10th, 2024 ruling applying the statute of limitations doctrine to the defendant's writ of error coram nobis claims. I hope Doug validates me, because when I was reading this argument from the state, I'm like, I'm not a lawyer, but this seems like they're like jumping from A to Z and missing a key detail here. So they're going to address paragraph 17 of that motion and say, well, an overview of the case with the understanding that Jason Autry tainted irrevocably the fairness of the trial and proceedings by committing perjury to avoid the death penalty. So look at how vague the state's motion to dismiss was. Doug Bates, Crystal Lee too, they come in here and they're like, let's just spell it out. They respond to paragraph 19 by saying, this is largely irrelevant at this point because the court did not dispose of the coram nobis case based on the defendant having the ability to present those issues in the underlying proceeding. They did it on the statute of limitations issue. However, the allegation here is that defense counsel could have penetrated Jason Autry's anticipated and actual trial testimony for being the he said the purchased perjured testimony. Now that's alliteration I can get behind. The purchased perjured testimony. I think that is a great characterization. Hilarious. They say paragraph 19A is abandoned entirely in this post-conviction proceeding. And let's pull that up to see what they're saying they're not even arguing. So if we go back over to paragraph 19 in the state's motion to dismiss. Oh my God, are they not numbered? How am I ever going to find what paragraph it is? Or maybe they mean 19 in their petition. All right, second amended thing. 1919. Failure to present. Okay, they deleted this issue. Yeah. Hilarious. They say 19A was abandoned. So yeah, that's deleted. B and C is the allegation that Ms. Thompson poorly cross-examined Jason Autry. Paragraph 35 and 35A are the allegations that defendant specifically is seen on an ATM recorder the morning of the victim's abduction and killing. 36 is the request to merely certify to this court that Jason Autry's recantation and his forthcoming testimony, this is underlined, taken with the other evidence that tied Jason Autry to being with Zachary Adams on April 13th, 2011, proves that he's actually innocent. And 37 is just a summary of 35 and 36 being judicially cognizable in this PCR proceeding. At the onset, the state and defendant have a fundamentally different reading. Oh, he said, well, you're reading a totally different law book than I am. Oh, man. Love it. Reading a fundamentally different reading of the Tennessee Superior Court Rule 28, Section 2E, which provides that a claim for relief is previously determined if a court of competent jurisdiction has ruled on the merits of the claim after a full and fair hearing at which petitioner is afforded the opportunity to call witnesses and present evidence. So did they just cite that whole thing wrong? Did they just cite that whole thing wrong? They stopped right here. Let's look at the sentence. Let's look at the sentence. This is where they put the period. Right after a court of competent jurisdiction has ruled on the merits after a full and fair hearing. So did they just not... Did they just ignore this part? Or are they going to say that the hearing in front of Judge Creed McGinley was full and fair? How do we think Doug's going to attack this, chat? How do we think Doug's going to attack this? He says it's hard to fathom the state's position. The state successfully dismissed the writ of error not on the ground that Jason Autry testified truthfully at trial. Instead, and only instead, the court dismissed the petition because the video of Autry's recanting and petition relying on it did not establish by clear and convincing evidence Zachary Adams' actual innocence. And under the new State v. Clardy standard, the case was dismissed without an evidentiary hearing by virtue of the statute of limitations. Oh! Oh! Also, shout out to Christy. I think what Christy's referring to here is the transcripts. So we are going to keep your notifications on this weekend, you guys, because we might do like reading streams and then a watch stream. So 2 streams a day up until this hearing on Monday, because I want to go through those sidebars, and Christy's making it possible for us to do that. Thank you so much for getting that uploaded. I think maybe we can try to get through these docket motions by like tomorrow, and Sunday we can do the sidebars and then watch Doug's opening statement at these post-conviction proceedings. I think that'll be how we do it. DB says, how will Doug attack this? With 2 arms tied behind his back with style. Hey, Nurse Janice. Hey, Miku's Headphones. Good to see you. We've also got Julie in the building. Good to see you, Julie. Montana Lil. Good to see you. Saying good morning to everybody. Why is Kells left and came back and ended up being late? I do that all the time with YouTube. I'll leave like a stream up that's about to start, and then it doesn't start automatically, and then like 45 minutes into the stream, I flip over to that tab, and I'm like, oh my gosh, it never started. Hey, Aaron. The Aaron gang is showing up. The Aaron gang is showing up. We've got Peter Max in the building. Good to see you. Hey, Gwennon. All right, you guys, let's see how Doug attacks this. So he says, it is hard to fathom the state's petition. The state successfully dismissed the writ of error not on the... Oh, wait, I read this whole thing. Yeah. So, no hearing. It was dismissed on the grounds of statute of limitations. And the reasoning was that we didn't reach a certain standard based on what was shown. Perhaps a review of the state's own filing. Oh, what are we doing, Doug? What are we doing? He says, perhaps a review of the state's own filing might jog the court's memory as to why there was never a full and fair hearing at which petitioner is afforded the opportunity to call witnesses and present evidence. So here we have cited from the 9th of May, 2024, the motion to dismiss Petitioner Adams' writ of error coram nobis without an evidentiary hearing. So then Doug continues. It's difficult to grasp the state's contention that somehow the coram nobis court held an evidentiary hearing or rested its ruling on any other ground other than the statute of limitations. See, this is exactly, I was confused reading the state's argument to motion to dismiss, because it was coming off as if their argument was, well, if one court heard it, be all end all. And that might be the way things play out, because the next court might say, look, I'm also going to dismiss this without a hearing. But that's not truly the end of the available options. He says, putting aside the plain language of Rule 28, the phrase on the merits has been clearly defined for this court within this statute. The defendant further questions the applicability of res judicata outside the plain terms of Rule 28. The provisions of the Post-Conviction Procedure Act do not, as a matter of law, bar multiple suits attacking the same conviction. And he says, see Swanson v. State. In the case of Swanson, our Supreme Court held, the Act does not necessarily contemplate that one and only one post-conviction petition will be allowed to any one petitioner in every case. Well, that is a powerful line. That is a powerful line. The terms of the statute itself permit more than one petition when justified. Like any legislation, the Act is to be construed in pari materia to achieve its intended purpose. And pari materia, quick look, you can kind of guess in context what it means, but it's Latin for in the same matter. In the same matter. Let's see. And that was Laney v. State. The problem with the state's argument here is multifaceted. Can you imagine if someone tells you your problems are multifaceted? The flaws in your argument are multifaceted. In the first place, the Supreme Court specifically addressed the ways in which res judicata would apply in this case pursuant to Rule 28. It is stipulated this court's ruling on defendant's coram nobis claim was a final judgment from a court of competent jurisdiction. It was not, however, on the merits, nor involving the same cause of action as it relates to these two proceedings. Yep, and I agree. And again, I'm not a lawyer, but when we were reading, this is like the first thing that stood out to me. The state was arguing, final judgment on the merits and on the merits. But that's not how I remember reading the judge's order. So now we're going to break down on the merits. We have a whole section with a header, in quotes, on the merits. So we've got to tell the state what on the merits would actually mean. From Britt v. Usury, maybe not Terry Britt, but there's a lot of Brits. There's a lot of name overlaps in this case. Addressing the on the merits language in the context of res judicata determination, the Tennessee Supreme Court interpreted the operates as an adjudication on the merits as akin to with prejudice determination. In Regents Bank v. Prager, the Tennessee Supreme Court assessed whether a trial court's dismissal for failure to prosecute otherwise specified that it was not on the merits for purposes of res judicata. In Prager, the trial court dismissed a case for failure to prosecute and orally specified that the dismissal would not bar the plaintiff from refiling the case. The court noted that the language of Tennessee Rules of Civil Procedure 41.023 certainly is clear that such a dismissal operates as an adjudication on the merits. But due to the trial court's ruling that the dismissal would not bar a refiling of the suit, the Tennessee Supreme Court held that the order otherwise specified it was not on the merits under Rule 41.023. Therefore, because the original dismissal was not on the merits, res judicata did not bar the subsequent refiling. Similar to Henry v. Goins, The analysis interpreted the on the merits language of Rule 41.023 to mean something akin to with prejudice rather than going to the underlying substantive merits. And then this is Patrick v. Dixon that says, holding that a dismissal for failure to prosecute was not on the merits and that the phrase with prejudice was a nullity. So it's void, nullity void. The federal courts have similarly noted that on the merits has two distinct meanings and purposes. One usage of on the merits, the more prototypical one, refers to resolution of a case upon its substantive merits rather than a procedural basis, and Doug is emphasizing this here. So, statute of limitations would be a procedural issue, while the other usage of on the merits is more limited in scope, serving as an indication that an adverse judgment is entered with rather than without prejudice. So specifically, we looked at the merits and we're going to dismiss this, and you cannot refile it. The United States Supreme Court has interpreted the adjudication upon the merits language found within the Federal Rule of Civil Procedure 41B as using the language in the narrower sense, that it simply means with prejudice. Explaining the meaning of adjudication upon the merits in the context of Rule 41B, the Supreme Court stated that an adjudication upon the merits, as ruled in 41B, is the opposite of a dismissal without prejudice. That is, it is a dismissal that prevents refiling of the claim in the same court. They've got another quote within a quote here. We've got nested quotes. For the proposition that both parts of Rule 41 use the phrase without prejudice as a contrast to adjudication on the merits. And then also another case that says for the proposition that with prejudice is an acceptable form of shorthand for an adjudication upon the merits. And I think what Doug's going to end up saying is we don't have this language existing for this petition for post-conviction relief. This petition for post-conviction relief has never been dismissed with prejudice. And the related claims raised under the coram nobis were dismissed on procedural grounds, statute of limitations. So, let's see, we've got exploring the two different meanings. Justice Scalia, writing for the Supreme Court in Semtech International Incorporated, drew a divide between the with prejudice understanding and what he described as the original connotation of an on the merits adjudication, which is one that actually passes directly on the substance of a particular claim before the court. And then they quote the restatement of judgments, a comment from Justice Scalia. He observed that the latter connotation remains common to every jurisdiction of which we are aware. This is a lot of case law. And again, we're coming from the motion from the state. I've still got my drawing. Here, where they just go, bloop. They just say, here, all of this stuff, just get rid of it. Just get rid of it. So a bit of a different approach here. But again, one is fighting for their client's innocence and doing so with very passionate advocacy, if I do say so. All right, so let's see. They've got, in sum, on the merits has two distinct meanings. One is related to a determination turning upon the substance of the claim, and the other is a means of communicating that a determination is with prejudice. The former, a decision turning upon an assessment of the substance of a claim, is the more prototypical usage, and that's coming from the Britt v. Usury case. So they're circling back to that same case that we started with. That's relying on all of these underlying citations. So, precedent on precedent. In the present case, the only coram nobis finding applicable here is that Jason Autry's video recantation does not, in and of itself, prove actual innocence. The finding may implicate paragraph 36 and only paragraph 36. However, every other ground leaves the coram nobis court unscathed by any issue from Rule 28 or the doctrine of res judicata. So, these other issues that we raised in this petition weren't even part of the coram nobis petition. Counsel will perhaps need to submit evidence at the hearing regarding this video recorder. This recorder was not obtained until May of 2024. Oh, is this the ATM thing? Cool. Okay, so we're finally getting this is We are all the way in the beginning of January. This is January 13th. So this is like the fire is turning up on a subpoena gate for this ATM DVR and speaking with the manager. They say this recorder was not obtained until May of 2024 under a subpoena which the court has apparently did not sign after an informal request from the clerk. To be clear, this video could well prove the actual innocence. This evidence is apparently in the state's custody and control, and it is impossible for them to now argue that this issue is somehow previously determined. Yep, if you knew we were fighting to obtain something, they trapped themselves. I never even really thought about it this way. By the state sending Kathy Ferguson to Alabama to get this piece of equipment, it's indisputable. You cannot say that there is not something new now. Whereas if they didn't do that, if they didn't go obtain a new thing, a new device, Doug would not be able to put this paragraph in here. That's so funny to me. That is stepping on a rake. And I never really thought about it as like, I thought about it like stuff that they withheld, stuff that they knew was out there, stuff that they didn't want the defense to get. But the fact that they go and get it for the first time themselves to beat them from getting it, I didn't really think about how important that would be for, hey, there's something new that a court's never heard before. A new issue. Oh, what a beautiful thing. Love the way that all worked out for the state. To be clear, this video could well prove the actual innocence. This evidence is apparently in the state's custody and control, and it is impossible for them to now argue that this issue is somehow previously determined. That is just a beautiful argument that the state set up. The state made this argument possible. Further, the state has failed to adhere to Rule 28, Section 5G, that must include the facts relied upon to support the motion to raise as a defense. All new evidence claims raised by Petitioner Adams' second amended petition for post-conviction relief facially cannot satisfy the Dellinger standard. So they're addressing the state's argument here. The defendant submits the following response to each of the paragraphs under attack. For paragraph 18AB, it is stipulated that Adams' forthcoming testimony about his innocence is not a standalone ground for relief. However, it is relevant for the denial of effective assistance of counsel claim. And was that just about his right to testify? What was 18? All right, so 18, defense counsel failed to find, develop, and otherwise introduce the following exculpatory evidence. Paragraph A is like this whole timeline with the bank statements. And then B was the computer and phone calls and the whereabouts, getting the gas, going to Sonic, this whole table. So that's what they're talking about here. 35 and 35A and parts of 37. It is submitted that encrypted data that reveals a recording of Zachary Adams with Shane Austin and Dylan Adams on April 13th, 2011 at the CB&S Bank shows that on the morning of April 13th, 2011, they were not killing, raping, or kidnapping anyone. It is remarkable that the state does not welcome this evidence, but says it is not scientific. Paragraph 36. It's not scientific, but they ran to Alabama to get it. Paragraph 36. It is stipulated that Jason Autry's recantation does not comply with the strict ruling and holding in Dellinger. As stated, the defendant wishes to preserve this issue for appellate review. So they're not arguing on that. And that seems to be what the state was hinging on. And then they're going to address the third argument, the third and final argument. Substantive constitutional claims raised by Petitioner Adams' second amended petition for post-conviction relief are barred on waiver grounds. Well, the state argues the following could have been argued in September of 2017 to the trial court. Oh, this is going to be spicy. The state argues the following somehow could have been argued in September of 2017 to the trial court. Paragraph 38. That somehow the defendant would have credibly shown to the jury the 2023 recanting of Jason Autry, his 2023 statement that he worked with the state as an agent of the state to secure a conviction for the state, while knowing his important testimony was false. that in 2020, ADA Paul Hagerman would say it was an important piece of securing justice for Holly and, quote, answered many questions that were left open factually in the investigation and many questions Karen and Dana had with what happened. Further, the state would argue Mr. Adams should have been able to submit into evidence certified copies of Mr. Autry's plea deal and conviction that became final some mere 3 years in the future. Some mere 3 years in the future. There was no waiver because the events relied upon in this standalone claim had not occurred yet, and to argue otherwise is an error. I can hear this in the Doug Bates voice in the courtroom. Paragraph 39, it is stipulated that Ms. Thompson could have explored the standalone claim in the trial court. To the extent it is an independent basis, not the foundational basis for ineffective assistance of counsel on this specific issue, the court can dismiss it. So that would have been 39. Let's see. The Holly Bobo that Zach Adams and Shane Austin were at Holly Bobo's house to teach Clint Bobo how to make methamphetamine and confronting that lie. Where either Clint was lying or Jason Autry's story was a lie. All right, paragraph 41 and 42. It says also see the argument on 38. That the point is that Mr. Autry recanting and the circumstances now exploring both the state's treatment of Mr. Autry pre- and post-trial are relevant and could not have ever been presented to the court outside of time travel. 44 and 45. Here again, the state tried to kill a man, Autry, for a crime it eventually settled on 8 years, time served, concurrent with other unrelated crimes. That only became apparent after the motion for new trial was denied. And that's critical too, because remember, we've talked about it where it sure seems like the state was waiting for the appeal to run its course and then say, you know what, we can put the ink on paper for Jason Autry finally. A procedural vehicle the state controlled. 100,000%. Put simply, none of these issues were waived. They were not anything that Zach had control or input into. Only the state could have maneuvered in this manner. So how could Zach have the power to waive the timing of which the state finally offered this plea deal to Jason Autry? The state could have avoided this by pleading Autry out and having these issues presented to the jury, but they cannot eat their cake and have it too. Tell them, Doug! And rest behind the waiver doctrine when the events had not taken place. Wherefore, premises considered, the petitioner-defendant respectfully requests that this court enter an order dismissing the state's motion to dismiss on the grounds except as stipulated above. So, signed by Doug and Crystal. I love that. I love that. That was nice and short, but it got right to the point. Yeah, docket decoder. I think we all have a ton of questions about the reward money. And, I think it's notable. I think it's more notable that Doug seemingly started to ask about this reward money, and it was almost like he was asking the questions at these post-convictions hearings with each new witness as a formality, as a habit, not really expecting that they were going to give him an answer. Because, of course, none of them did. I don't know. I don't know if anyone ever got it. Well, who's in control of the reward money? Well, not me. So, just one big mystery. One big mystery. And again, yet another thing that you cannot confront in the 2017 trial any of these witnesses if you still can't get the information out of the state who should have awareness of that information in 2025. Hey, Amy. While I'm screaming at my screen, the wonderful Amy E comes in. Good to see you, Amy. Hope you had a wonderful, wonderful holiday. I miss you guys. Can't wait to come hang out after the 30th when these hearings take place. I always joke that when I'm covering a trial or a case, as soon as it's done or there's a long break, I retire temporarily and go hang out with Amy and Classy over on their channels. I also saw a ton of Reigned gift memberships here from Autry's Fake Accent. New membership walking. We got to come up with a phrase for new members. Oh my goodness. Thank you for becoming a member yourself. And then also gifting 5 memberships twice, making 10 total. So this is the one chance you get to thank an Autry. We get to be grateful for Autry's fake accent today. So shout out to the good Autry here in the building. Thank you very much for the 10 gifted memberships. It's super generous. And guys, if you got a membership, say thank you. Check out those channel emojis. Throw some Doug Bates emojis out there in the chat. I think they did great with this motion. And again, I read these things. I let you know if I've read something in advance. Typically, these things are blind readings for me. And or sometimes I'll skim the result. Like I'll go down to the conclusion section and see what they're asking for, post it over on X, and then come over here to do a stream on it. But reading this motion to dismiss from the state, the first thing we read on this stream, I'm like, dang, is it really this simple? Zach's supposed to have no chance? And I'm reading it knowing that we still have these hearings. But I'm like, dang, if I accept their argument at face value, trust them that they're applying the law the way it should be applied, doesn't look good for anybody that wants post-conviction relief. And then you get over here and you're like, no, the state is just talking out of their ass, really. And I'm going to assume we're going to get further down the line and the judge agrees in part because we still have the hearings going on. So the next one we have up, I think that was January 13th, 2025. And then we've got, let's see, the next date. Okay, so we jump. So there's going to be a hearing. There was a hearing on the 16th, or I guess the 17th. I thought it was the 16th. And then on February 3rd, we have an order. So let's see. Order on the January 16th, 2025 hearing. This matter came before the court on January 16th for a hearing on the state's motion to dismiss post-conviction claims and the state's motion to inspect all documents and exhibits filed under seal prior to the post-conviction filing. At the hearing, petitioner indicated no opposition to the state's motion to inspect the documents filed under seal to the post-conviction filing. Accordingly, this court granted orally the state's motion and directed the state to prepare a separate order for the court on this motion. During the hearing, the parties presented arguments related to the state's motion to dismiss post-conviction claims. And this had to have been, like, I don't know, the air in this room for this hearing had to be thick with animosity, like, just really tense. Because this is like the last shot for Zachary Adams to have a shot to present his arguments for post-conviction relief. Because the state was arguing at this point, dismiss it without a hearing, dismiss their whole petition, shut it down, end it here, close the road here, dead end. So this must have been just a really, really important hearing. And then he's saying here, both in his response and argument, the petitioner conceded paragraph 36 of the second amended petition was a writ of error coram nobis claim not available for post-conviction relief in these proceedings. Accordingly, the state's motion to dismiss is granted in part without objection as to paragraph 36 of the second amended petition. And that was the Jason Autry thing, the recanting. Yeah. So the remainder of the state's motion to dismiss post-conviction claims, however, contains substantive claims mixed with either claims of ineffective assistance of counsel and or state misconduct. Accordingly, this court will take the remainder of the state's motion to dismiss under advisement until after the evidentiary hearings in this matter. So that's why we have all these hearings. Also at the hearing, the petitioner's counsel clarified that the second amended petition superseded the first amended petition, but it did not supersede the pro se petition originally filed. Accordingly, this court orally ordered the state to file an answer to the issues raised in the pro se petition and the first amended petition within 30 days of the hearing. However, 30 days from the hearing date falls on a Saturday, so the answer is due the 18th of February. So there we go. There's Judge Bradbury not giving the state what they wanted. And let's see. Next up, we have February 7th. And of course, what do we see the state do every time that they lose something? As soon as they lose something, even if they're supposed to be busy turning something over or filing responses, they waste no time going to the court and saying, hey, the state wants the defense to give us stuff. They have to do something too. And it's something that I felt like we saw a lot with Adrian Love in the YSL trial. That anytime, an issue is addressed and the court issues an adverse ruling to the state, or informally says, state, you need to get something together, Love was always ready to just stand up and announce in court, hey, well, can you ask the defense to turn over a list of this? And sure, at some point, the state may be entitled to that disclosure or being put on notice or something. But usually there's like a narrower time limit, like let us know what witnesses you're going to call within however many days that you're actually going to call them to the stand. But Adrian Love would do this just as you just yelled at me, I just got criticized, I'm embarrassed, and I want to level the playing field, so I need something to point over at the other side of the aisle. This is the third or fourth time that I feel like since we started watching this stuff back in November, we've seen the state, we've seen Amy Weirich jump up and say, well, we need them to give us a list of this. So here they are, a few days after that order, saying, hey, we want the court to issue a subpoena ducis tecum, so we want documents, we want some type of records from the defense team for the production of certain items before the court at a time prior to trial. This motion aims to allow the parties to inspect and request items before their introduction into evidence, thereby avoiding any delays. So we want anything relating to Jennifer Lynn Thompson, Jim Simmons, Jerry Gonzalez, Katie Spiro. The state of Tennessee would submit that the items are evidentiary in nature and relevant. They are not otherwise procurable by the state of Tennessee in advance of trial, and that the state cannot properly prepare for trial without such production in advance of the trial. Yeah. I mean, maybe they want to get this stuff from the clerk, but I don't think this would be... Okay, so they want attendance or hearing at trial and evidence. Or no, this is the only one that's checked. Okay. All right, so what do they want? So from Jennifer Lynn Thompson, the complete case file, all statements and memos relating to witness or potential witnesses or persons connected with the Zachary Adams case, all documents, tape recordings, or other writings memorialized or in any way recording or reflecting any words, statements, declarations, conversations, or other communications by Zachary Wright Adams, all documents, tapes, and there's work here, right? Because it might be necessary to have someone sit there and say, hey, we have to object to this request because we can only send you what isn't covered by attorney-client privilege. I don't think we had a Jim Simmons. I think he testified, but I don't think I saw a video of that. They want all documents, all recordings, any communications by Jason Autry, any and all letters, notes, memoranda, or writings. Wouldn't we love that from you, state? The audacity to ask for any documents, tapes, or other writings memorializing or in any way recording or reflecting any words, statements, declarations, conversations, or other communications by Jason Autry. Wouldn't it be awesome and expected and normal if the state had notes from their proffer sessions with Jason Autry? Thank you, Derek, for the super sticker. Good to see you. Hope you are doing well. Hope you had a great holiday and are enjoying your evening. We've got, they want everything from any letters, any notes, any photographs, any letters, documents, discs. Yeah, I bet it would have been nice for Zachary Adams' team to have the discs that you only sent over to Jason Autry. Digital files, All computers, laptops, hard drives, backups, and computer information storage devices that you have in your possession related to any legal work representation in the Zach Adams case. All records and notations of communication to memorialize any communication or contact between Jennifer Thompson and Zach Adams. Copies of any and all documents, and then every signed application for membership in the Criminal Justice Act Defense Panel for the U.S. District Court for Middle District of Tennessee since January 1st, 2015. What do they want from... Who's next? All right, so from Jim Simmons, they seem like they want the same thing. A bit shorter. Jerry Gonzalez, same thing. And Katie Spiro. Katie Spiro, they want all documents and records provided to you or to any third party at your request or direction as part of your involvement with Zachary Adams or any subject matter related to State versus Zachary Adams. Please bring a copy of the professional guidelines that you consider as governing you for your work in this post-conviction case. If more than one organization's guidelines apply, please bring all applicable. Please provide a list of all cases in which you've given expert testimony, either in person or by deposition in the past 5 years. Please bring a copy of all papers submitted for publication or to fulfill academic requirements, including but not limited to your dissertation. Please bring a copy of the case file in your possession for the State of Tennessee versus Zachary Adams. All computers, laptops, hard drives, backups, and computer information storage devices. All documents, tape recorders, statements, declarations, conversations, or other communications with Jason Autry. All documents, tape recorders, or other writings. Zachary Adams, same thing. And then same thing with Jennifer Thompson. And then please provide a copy of any employment contract that you have with Zachary Adams. So there's that. All right, and then now, February 13th. And it's Zach Adams' response to the motion for those subpoenas. So counsel for petitioner does not represent any of the 4 individuals subject to the subpoena. Thus, any subpoena that is issued by either party would be subject to any and all objections from the party sought to be subpoenaed, in addition to the grounds that petitioner may assert in such subpoena. So we're going to get a privilege issue, I'm sure. Counsel does object to the issuance of any subpoena to any witnesses who are not going to be witnesses, which in this case is Dr. Katie Spiro. Petitioner is not calling her as a witness. The state is not either, as they did not include her on their discovery list as a witness. And this is where the state's like, oh, quick, we got to put her on the witness list. Further, there are privileges and protections that bar the subpoena being granted that Dr. Spiro will submit to the court if necessary. Finally, the subpoena violates Rule 16 of the Tennessee Rules of Criminal Procedure and is not permissible under Rule 28, Section 6 and 7 of the Rules of the Tennessee Supreme Court. Further, counsel for petitioner requests that neither Mr. Simmons nor Ms. Thompson be required to produce any document they relinquish in its entirety to counsel, as counsel opened his entire office to the state to copy virtually everything but the sparse amount of its own current work product in this case. Counsel believes the subpoena means only to cover what was not relinquished to counsel, but just wishes to be sure. Yeah, you got to take that step when you're dealing with somebody that isn't coloring between the lines. Counsel further requests the ability to utilize a date both before the March 18th, 2025 date and after the March 18th, 2025 date for the same reasons for petitioner's witnesses, the list of which will be provided once the state answers the petition. All of the issued subpoenas would be subject to a motion to quash and the availability of the witnesses. So there's Doug and Crystal. All right. Let's see. All right, next up is from the defense, from Zach Adams, on February 14th. This is an order for writ of habeas corpus ad testificandum. So think of this like a subpoena, but there's an extra layer. When you want to subpoena, you need something from somebody that's a ward of the state, that's in the custody of the state. You need a writ. you need to go to the person that's holding them in custody and is ultimately in charge of that person, that body. So here, Zachary Adams is requesting this for Jason Autry, and they're saying, hey, he's currently incarcerated. This is where he's incarcerated. He's at the U.S. Penitentiary McCreary in Pine Knot, Kentucky. Well, dang. And he was a material witness, so we need him. His testimony is necessary for the evidentiary hearing currently set for March 18th, 2025. As such, Mr. Autry is beyond the jurisdiction of this court and cannot be subpoenaed pursuant to Rule 17 of the Tennessee Rules of Criminal Procedure. The petitioner is indigent within the meaning of the law and cannot pay the cost of having Mr. Autry brought to Hardin County, Tennessee, and returned to U.S. Penitentiary McCreary. Therefore, all necessary and proper costs associated with the transport of Jason Autry, as well as the detention and housing of the witness, must be paid by the state of Tennessee and adjudged as costs against the petitioner. Pursuant to Tennessee Code Annex Section 41-21-305. And I don't know what CFR stands for. Federal rules? I don't know. Oh, the acronyms get me. There's too many. But these two things, pursuant to these two things, in my most elementary reading, the clerk of this court shall issue this writ of habeas corpus ad testificandum to the warden, Christopher Gomez, of McCreary at Federal Way in Pine Knot, Kentucky, to bring Jason Wayne Autry to Hardin County, Tennessee, and place him in the custody of the sheriff of Hardin County. So they want him to appear on March 18th, 8:30 a.m. And then immediately he can be returned back to the custody over in Pine Knot, Kentucky. Code of Federal Regulations. Look at DB. Look at DB here in the chat. I'm like, oh gosh. Because when I saw C, I'm like, criminal, federal. And then my brain didn't want to think of anything else for C, and it didn't seem right. Yeah, we need a Latin. We could pick a Latin word and make an emoji for it. Deuces tecum. Or just deuces, but spelled like the Latin way and not like... We've got, next we have a notice. Oh, it's just a quick one. All right, so it's just a copy of the order that the judge could sign for what they just asked for. Next is February 18th, I think. I have it as February 18th in my notes. Let's see when this is signed. Are we just not doing dates? All right, well, in my notes, that's what I have. So when I downloaded it from the website, they marked it as February 18th. So State of Tennessee's response to Petitioner Adams' petition for post-conviction relief pro se and second amended petition for post-conviction relief. So they're responding to both in one answer. So State of Tennessee responds stated as followed. They're answering. All right, they're admitting to 1, 2, 3, 4, 5 in part. 5, they say Petitioner Adams was convicted of first-degree premeditated murder, 2 counts of first-degree felony murder, 2 counts of especially aggravated kidnapping, and 3 counts of aggravated rape. So I think they're just correcting the statement of facts, the procedural history. We got 6 and we've got 7. We get an Ipsy Dixit one. Yeah, that could be good. We might need to just do like a coram and coram. Just make fun of the state for spelling it wrong. All right, admitted. 10, they bold. They say, I guess it's issues from the appeal. And they're fine with everything until we get to the grounds raised on appeal. They're correcting, they don't agree with sufficiency of the evidence. They say, admitted that Petitioner Adams raised this issue in his direct appeal to the Tennessee Court of Criminal Appeals. Motion to recuse, same thing, that he raised this issue in his direct appeal. Disqualification of defense counsel was raised in his direct appeal. And that's related to Luke Evans. Tennessee Rule of Evidence 404B, Jason Autry, raised in his direct appeal. The issue with Rebecca Earp's 404B evidence. Well, 404B for Zachary Adams brought in through Rebecca Earp. Writ was raised on appeal. Prior inconsistent statements was raised on appeal. They're saying all of these things were raised on appeal. So hearsay evidence and confrontation rights, impeachment evidence, witness reactive conduct evidence, undisclosed witness, cumulative error doctrine. And then they say they're not addressing anything. There's nothing to address here. And now they're going to address some grounds for petition. So relating to grounds raised for denial of effective assistance of counsel, under claim for relief 1, that trial counsel failed to sufficiently review discovery materials. The state of Tennessee denies this claim. And let me clarify. So we're stepping away from, hey, we went through the procedural history. We just made this one correction about the charges he was actually convicted of. Then we went through and said, hey, all of these other issues were raised on the direct appeal, which was denied. And now we're moving on to addressing certain arguments. Namely, first, we're starting with ineffective assistance of counsel. So under claim for relief 1, that trial counsel failed to sufficiently review discovery materials, the state of Tennessee denies this claim and demands strict proof thereof. 2, under claim 2 for relief, the trial court failed to request a change of venue further away from Decatur County than Hardin County. The state of Tennessee denies this claim and demands strict proof thereof. Under claim, how do you demand strict proof of a failure to request a change of venue? I mean, wouldn't that be on the docket or not on the docket? And or not in the transcript of any hearing that might be related to that issue being raised? Because it's kind of like, if someone didn't do something, the proof would be that the record keeping, it's not there. Under claim for relief 3, the trial counsel failed to investigate an alibi defense from evidence located on Petitioner Adams' deceased grandmother's computer in preparation for trial. The state of Tennessee denies this claim and demands strict proof thereof. They say that relief 4, that trial counsel failed to send an appropriately worded TUI letter concerning the testimony of U.S. Marshal John Walker, thereby limiting the scope of his trial testimony. The state of Tennessee denies this claim and demands strict proof thereof. Under claim for relief 5, that trial counsel failed. What didn't the judge like not know what a TUI letter was or something? Didn't someone not know what a TUI letter was? That's vague. I remember someone in the chat saying, like, recalling it. That's kind of funny. Like, probably a good sign that they didn't do this appropriately if we have questions over what exactly it even means. Under claim 5 for relief, that trial counsel failed to adequately investigate a partial palm print found on the victim's car in preparation for trial. The state of Tennessee denies this claim and demands strict proof thereof. All of these things are like, they said we didn't do this, but we want you to show strict proof that we didn't do it. Well, then the way to prove that would be, hey, look, we have nothing in our discovery folder that shows like a testing, that they sent this handprint for test, or that they tried to ask somebody else for their handprint and decided it was or wasn't a match. If those things aren't in there, then that's shows that it wasn't done. Because there's a requirement for the state to document the things that it's doing. Oh, man. Just like 700 Yeti arguments here. Sasquatch arguments. Tree falling in the forest. Under claim for relief 6, that trial counsel Jim Simmons filed an ex parte motion to withdraw that violated Petitioner Adams' right under the 6th Amendment of the United States Constitution in Article 1, Section 9 of the Tennessee Constitution, and violated attorney-client privilege. The state of Tennessee denies this claim and demands strict proof thereof. Under claim for relief 7, that ADA Jennifer Nichols improperly cross-examined Rita Austin at trial concerning a letter written by Shane Austin. The state of Tennessee denies this claim and demands strict proof thereof. Furthermore, the state avers that this ground is waived for failure to raise this issue on appeal, pursuant to Tennessee Code Annotated 40-30-106. Post-conviction is not intended to serve as an additional avenue to raise evidentiary issues when those issues were not raised and ruled on by an appellate court. Well, funnily enough, if you're asking for all this proof for everything else, sounds like you need an evidentiary hearing. Grounds raised for newly discovered evidence. So the state of Tennessee denies this claim and demands strict proof thereof. Furthermore, this claim does not provide specific factual allegations required under the Tennessee Code Annotated 40-30-106D, and as such does not state a colorable claim. So whatever was in 17, 18, 19, 20, and 21, they're admitting. What was it? 17, 18, 19, 17 through 21. And I don't know if they're referring to the pro se petition still, or if they're talking about the second amended petition. You know, this is the territory of Mr. Simmons made a fatal flaw and casting the die to the court that Ms. Thompson was in the wrong. New evidence. It seems to jump if we were to think that this might be referring to the pro se. And then on whatever 22 is, they say no statement made by Petitioner Adams in this paragraph that they're going to admit or oppose to. Answer to petitioner's second amended petition for post-conviction relief filed on December 12th, 2024. They're admitting like 1 through 7, and then 8, they're saying, hey, no answer was filed by the state of Tennessee as of December 12th, 2024, due to an understanding between the parties that Petitioner Adams would be filing a second amended petition for post-conviction relief. So there's probably just something referred to as a due date. Whatever 9 was, they admit in part that there was an evidentiary hearing set for March 18th, and so probably a date change. Like, yep, but we had some date changes. The allegations contained in paragraph 10 of the second amended petition, including all subparts, are admitted. 11, denied as stated. 12, the allegations contained in paragraph 12 of the second amended petition. All right, so they're denying 12, denying 13, denying 14, denying 15. So everything related to ineffective assistance of counsel, they're denying and want strict proof. 16, 17, 18. So they're denying like everything else and wanting the proof, which isn't surprising. All the way down. And these longer paragraphs, they're just renewing other objections from their own motion to dismiss. Yeah, so it looks like they're just straight down. Once they get past the procedural history, they're like, oh, we deny everything. We want strict proof, and we, maintain all of our previous objections raised in our other motion to dismiss. So wherefore, the state of Tennessee prays for that an evidentiary hearing on the claims of ineffective assistance of counsel be conducted, that this court rule on the state's motion to dismiss post-conviction claims at the appropriate time to determine if certain claims raised in petitioner's second amended petition are previously determined, B, failing to satisfy Dellinger, and C, were waived. And 3, any general or specific relief that the state of Tennessee is entitled to. All right, so sorry that was a lot to scroll by, but we weren't going to read each line for line. There was no point in going line for line. Next up, we've got a bunch of tabs to close. All right, order on the February 14th Zoom hearing, it says. All right, so this is for, let's see. For a Zoom hearing on the state's motion for pretrial production of documents, the parties agreed the subpoenas were only for information not previously provided to Attorney Bates. Any issue raised by petitioner's current counsel related to persons other than petitioner's trial counsel was agreed to be premature at this time. After hearing from all the parties, the court instructed the state to draft the subpoenas requested with the compliance deadline of March 7th. In addition, the state was instructed to draft orders with the court's stated limitations related to the waiver of attorney-client privilege by petitioner's trial counsel, Ms. Thompson, Mr. Simmons, and Mr. Gonzalez. So, hey, when you draft those orders, don't try to be sneaky and just let it be carte blanche and you get a free pass to everything you want. You have to make sure you preserve, you're not requesting the subpoena to step over the bounds of attorney-client privilege. So it seems like Judge Bradbury had to say that out loud in court, remind them of basic things. They say also this court set a Zoom hearing for March 7th. The parties subject to the subpoenas for pretrial production of documents and objects shall appear on the March 7th Zoom hearing. All right, cool beans. So there's that order. All right, and then this says order setting hearing on state's motion. The trial court sealed certain pleadings and ordered that certain information not be mentioned at trial. The state seeks to have this court review certain sealed pleadings and information in camera and order that the pleadings and related information remain sealed in these proceedings. So the court will do this on the sealed hearing on March 18th. All further pleadings on those issues shall be filed under seal pending further orders of the court. So we won't see all that stuff. If there was stuff. On the 25th of February, emergency motion to allow counsel to have a Zoom hearing. So this would have been after. Okay, no, it wouldn't, because we're still in February. So it comes down the petitioner by and through counsel. They want the court to allow counsel for the petitioner to have a Zoom conference with Zach Adams at the Morgan County Correctional Complex on Friday, February 28th at 10 a.m. For cause, the petitioner would show that Morgan County Correctional Complex is no longer holding Zoom conferences absent a court order. So difficult to connect remotely with your client. So that sucks. On the 27th, there is a subpoena for attendance. This is, let's see, for Cindy Adams. So this is to Cindy Adams, Zach's mom. They want her to appear Friday, March 7th. At 1:30 p.m. Yeah, they're both for Cindy, and that's all I see. Just a general appearance. And then an order on that Zoom meeting request. So they probably granted it. Yeah, they shall have the privilege of meeting with Mr. Adams through Zoom technology. This privilege is not extended to anyone else beyond Doug Bates and Crystal E2, so attorneys of record. So there's that. And guys, we got through February. So now we're going to move into March. And March is like, there's like, on the 7th, there's like chaos on the docket. Like, look at all these filings on the 7th. Just chaos. Just chaos. So we will be moving into March. We're going to keep going until I lose my voice. I would love if we can get all the way through. March would take us down here. We'd get through all of this if we can get through March, which is a lot, but we're going to try to make a dent. We're going to try to make a dent. Also, I see still Santa, Sheriff Chuck. Christmas is still here. We're still celebrating. And we've got 10 gifted memberships coming in from Sheriff Chuck. Good to see you. Hope you had a great one. Thank you so much for the 10. Thank you, thank you. He said, oh no, there's still something left in my bag. Let me deliver it. Sheriff Chuck, if you just got here, I see Aaron's here too. Adventure Aaron, I gotta start saying the full names. And Destined to Be. If about the time that you guys came in, probably 15 minutes before that, we were reading Doug Bates' response to the state's motion to dismiss. And it was short, it was like 9 pages. I think he torched him. So I think that's if you haven't seen it, or let me get the link. I can just drop the link if you want to read it. I think it was this one. That seems like it was too far back though. But let's see. Okay, yep, it was this one. So I'm dropping a link in the chat. Oh, and it's okay. It's a long link, but it worked. It went. So either rewind or pull it up and read it quick. I think Doug Bates went bananas. Hey, Keisha. Hey, Slim Life. Good to see you. Good to see you both. Hope you guys both had a good holiday. Yeah, we got the Sheriff Santa love in the chat. Love to see it. Oh, Bailey's. I feel like on New Year's Eve, I need to be live when it's New Year's in Europe, in the UK. So that way, like, Factual Lie can be in the new year before the rest of us, and we're still all stuck in the past. Heck yeah, I hope he gets a new trial as well. For sure, like, for a million reasons. Anyway, back to this March stuff. Let's just see how far we can go. So this is an order, March 3rd. Let's see. They wanted a motion to deem attorney-client privilege waived for the post-conviction relief issues. Counsel for both parties were present in court. So this was back to November 26th, an oral hearing from the year before. And the court ordered, adjudged, and decreed that the state of Tennessee's motion to deem attorney-client privilege waived for post-conviction relief issues as to Jerry Gonzalez is granted in part as to the issues raised by Petitioner Adams in his post-conviction petition, alleging that his trial attorney's representation was ineffective. So I think this is what gave Jerry, he was able to discuss some of his conversations. I would imagine relating to discussions with Zach about his right to testify. And let's see. And then Jim Simmons, same order granted in part. And then Jennifer Thompson granted in part. So there you go. That's why there's 3 orders, because it's for each of those 3 attorneys. All right, next is about the Jason Autry thing. So motion for the court order approving communication with Jason Autry. So there's so much, and I wonder what order these were filed in. But again, this is starting that day of like docket chaos. All of these March 7th. So I don't know. We're just going to barrel through it and hope they're in the right order. So comes now Petitioner Zachary Adams by and through counsel, hereby moves this honorable court for a court order approving, if not objected to by Jason Autry, for Mr. Adams' attorneys to confer with Jason Autry either in person or via Zoom. The purpose of this communication is to prepare for the evidentiary hearing currently set for March 21st, 2025, on whether he will invoke his Fifth Amendment right and or refuse any questions under oath at this post-conviction relief petition hearing and or waive his attorney-client and or private investigator privilege. They're not letting up. They are not letting up. They are still having him, they're characterizing him as a state's agent. In the Zoom hearing conducted on February 26, 2025, this court advised it would not order the state of Tennessee to issue a transport request for Mr. Autry per the instructions received by USP McCreary. The state advised Mr. Autry was a too dangerous to transport individual. And they were, what's Latin for too dangerous? Is there a phrase? Maybe that needs to be the emoji. Oh, it's kind of boring. Periculum? That's boring. But yeah, Mr. Too Dangerous to Transport, per the instructions received by USP McCreary, the state advised Mr. Autry was a dangerous individual, and they were uncomfortable signing the order to transport him. The irony should not be lost on the court, as the state in 2017 transported him throughout the state to prepare for trial and then to testify at trial. Oh my goodness. My goodness. This is crazy. Oh my goodness. We've got The state of Tennessee has advised in a Zoom conference that they would not voluntarily issue the transport request and 10-point letter to USP McCreary, where Mr. Autry is currently incarcerated. The court advised it would not hold Mr. Autry's testimony by Zoom to answer the important credibility question. The court then advised it would be best to just see if Mr. Autry is willing to testify and suggested he be available at the March 21st, 2025 hearing by Zoom to advise everyone. Although the petitioner does not necessarily require permission from this court to confer with a witness, petitioner is requesting leave as a courtesy in consideration of this process, and further from the state's request on March 7th, 2025, that no counsel talk with Autry before their pending motions can be heard, which would in effect freeze any communication between counsel and Mr. Autry before he appears on Zoom. Undersigned counsel would like to meet with Mr. Autry, preferably on Zoom, in order to understand his potential testimony in this case and determine his willingness to testify at the March 21st, 2025 hearing. In no event will undersigned counsel demand that Mr. Autry meet with them, as it is strictly within Mr. Autry's purview. Furthermore, if Mr. Autry advises he is represented by counsel in this matter regarding his testimony against Zach Adams and his recantation and everything surrounding his charge and conviction for crimes against Ms. Bobo, then the communication will cease. Then they cite the rule of professional conduct. So, Rule 4.3, dealing with an unrepresented person. In dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. When the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. The lawyer shall not give legal advice to an unrepresented person other than the advice to secure counsel if the lawyer knows or reasonably should know that the interests of such a person are, or have a reasonable possibility of being, in conflict with the interests of the client. Rule 4.2 is communications with the person represented by counsel. So, in representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law or a court order. We've got comments 5 and 6 to Rule 4.2 further state, communications with represented persons may be authorized by specific constitutional or statutory provisions, by rules governing the conduct of proceedings, by applicable judicial precedent, or by court order. A lawyer who is uncertain whether a communication with a represented person is permissible may seek a court order. A lawyer may also seek a court order in exceptional circumstances to authorize a communication that would otherwise be prohibited by this rule. For example, where communication with a person represented by counsel is necessary to avoid reasonably certain injury. And then Rule 28, Section 6 states that appointed counsel shall be required to interview relevant witnesses, including petitioner and prior counsel, and diligently investigate and present all reasonable claims. So back to the reasoning here from Doug Bates, counsel anticipates the federal facility recording the conversation and providing the same to the state of Tennessee. Should the court wish for counsel to record the conversation, then the court will comply, though petitioner's counsel is unsure of the authority of this under Rule 16. Further, counsel will read the Rules of Professional Conduct 4.3 that specifically states counsel cannot give him any legal advice as the inquiry is for Mr. Autry to provide information to counsel, not counsel to Mr. Autry. So they want an opportunity to speak with Jason Wayne Autry in person or via Zoom. And let's see. Then they amend their writ. So a motion for amended writ of habeas corpus, and to compel the state of Tennessee. Oh, what are we doing here? What are we doing here? So this one, I thought they were just going to make a quick change, but what else are we getting? Before we do that, hey to everyone popping in. Hey to Linda. Hey to Mel. Hey to another Katie. I think we're growing a Katie gang today. We've got some Katies in the building. We've also got a Santa gang starting. We got Shout here dressed as Santa. I love it. Hello, hello. And you might have been here a little bit earlier, but I'm just now noticing the Santa picture. So, Charlie, thank you for the super. Says hi back. Thank you so much. We've got Aaron reading Doug's response. Yeah, perhaps a review of the state's own filing. Aaron, it was good. It was a good one. That was a good one. Yeah, definitely got the Katie and Aaron hybrid gangs going in the chat. Oh, love to see it. All right, so we've got this 5-pager here. Let's see what they're talking about. So Zachary Adams requests this court issue an amended writ of habeas corpus ad testificandum, that's a word, to ensure the presence of Jason Wayne Autry in this case. So we read the original earlier. Whenever the presiding judge of any court has reason to believe that the evidence of an inmate is necessary to any criminal proceeding and that other evidence cannot be obtained on behalf of the state or of the defendant, the presiding judge shall order a writ to be issued directing the warden of the penitentiary to bring the body of the inmate before the court on a day to be named in the writ to give testimony for the defendant in this case. So I wonder if they're going to amend this to just ask for the, Zoom. So we know he's alleged to be a material witness. He is necessary for these evidentiary hearings. He was a key witness for the state during the trial that resulted in Zach Adams' conviction. Autry has since recanted. He's offering new facts, and it's necessary for the adjudication of this post-conviction matter. He's presently confined in McCreary over in Kentucky. And so this witness is beyond the jurisdiction of this court and can't be subpoenaed the ordinary way. And nor can the witness be required to attend the trial of this cause through the provisions of the uniform laws to secure the attendance of a witness from within or without a state. So the only remedy available is the extraordinary writ of habeas corpus ad testificandum and an order from this honorable court compelling the state of Tennessee to issue a 10-point letter containing the prosecutor's certification to assist in facilitating this transport. Because the state said, no, he's too dangerous to transport. The petitioner alleges he is indigent within the means, so the state would have to bear these costs. And then let's see. I think this is all about the warden can authorize. The warden can authorize transfer when satisfied that the inmates, or shall authorize only when satisfied that the inmate's appearance is necessary, that state and local arrangements are satisfactory, and that the safety or other interests of the inmate, such as an imminent parole hearing, are not seriously jeopardized, and that federal interests, which include those of the public, will not be interfered with or harmed. Authorization may not be given where substantial concern exists over any of these conditions. The request for transfer of custody to state agents shall be made by the prosecutor or other authority who acts on behalf of the court. That's bolded. And shall be directed to the warden of the institute in which the inmate is confined. It can be made by letter. And then undersigned counsel has made multiple efforts to facilitate the transport of Mr. Autry, but to date, the state has been unwilling to assist in this endeavor. And despite the clear language of the CFR regulation allowing the request to be made by the prosecutor or other authority who acts on behalf of the court, the Bureau of Prisons seems unwilling to accept anything other than a 10-point letter from the state containing the prosecutor's certification. The petitioner is requesting Jason Autry be placed in the custody of the sheriff of Hardin County, Tennessee, and confined in the county jail during the pendency of the evidentiary hearing on the petition for post-conviction relief, currently set for May 19th. Autry would need to be picked up by the Hardin County Sheriff's Department on May 18th, confined in the county jail, and then returned to the exclusive custody of McCreary directly following his testimony. Ah, man. Do you guys say adventure Aaron or adventure in? Because I read adventure, I read it as adventure in. I don't say it as adventure Aaron, but I'll spell it out to if I'm clarifying, like, hey, I'm getting better at not just saying Aaron when I'm talking to adventure Aaron, adventure in, versus created by EJF, another Aaron. So adventure in says, definitely an I can't take it anymore type of motion. Yeah. It was a good one. All right, so this is the petitioner's first application for extraordinary relief in this case, and then wherefore we're asking that a writ of habeas corpus ad testificandum issue on his behalf directed to the warden of McCreary to release the person of said Jason Wayne Autry to the sheriff of Hardin County because of this hearing date. That this honorable court enter an order compelling the state of Tennessee to issue a 10-point letter containing the prosecutor's certification and to otherwise comply with the requirements of 28 CFR Part 527, Subpart D, for the transportation of Jason Wayne Autry, and then any other general relief as necessary. This motion is set to be heard on March 21st at 9 a.m. in the Circuit Court motion docket at the Hardin County Courthouse before Brent Bradbury. So there we go. They're like, dude, the state could just do this, but they won't, so please compel them. All right, next, and this is all March 7th, guys. All of these are dated as March 7th, 2025. So we've got petitioner's renewed motion for subpoena and depose if necessary, and scheduled testimony from attorneys and private investigators. So we're renewing. In substantial part, previous motion to request to order the scheduling of depositions or trial testimony for Michael Scholl, Michael Flanagan, Paul Hagerman, Clark Chapman, who was the private investigator for Mr. Autry, and he was not part of the original motion. Oh. A drafted copy of the subpoena ducis tecum were attached to the motion. All three attorneys were sent this motion and the drafted subpoena, so 1 through 3. Should they wish to participate in any hearing on this motion, then petitioner welcomes their presence. These witnesses are necessary to testify regarding the perjured testimony that Mr. Autry presented to this court and the ways in which he became a state agent in doing so, and other issues, all of which are addressed in the petition and amended petition for post-conviction relief filed by Mr. Adams. The 3 attorneys are exempt from a subpoena for the hearing, but are obligated to stand for a deposition. Initially, it would appear the attorneys involved would be subject to subpoena powers of this court to appear in person. However, under the Tennessee Code Annotated 24-9-101, the attorneys may and probably will rely upon their ability to stand for a deposition instead of appear in person. Well, they came in person, so counsel would further request the depositions take place via Zoom if petitioner or the state elect wish to have their appearance through Zoom. And I wonder, do you think there was anything at play where, with depositions, you got to barrel through, unless there's like an attorney-client privilege issue, which, I don't see why the state would have that issue. Or any attorneys for the state would have that issue. When you do a deposition, you can raise an objection, but the person's still supposed to answer anyway, and then if the objection is sustained, then their answer wouldn't be admissible for future proceedings. But the answers are still supposed to be given. Whereas if you testify in person, Amy Wyrick can jump up and object and maybe get the answer snuffed out before it's given. So, I don't know, maybe there's a reason that all of them wanted to run and appear in person. I love like historical usernames. One of my old names was like Sobe Lizard, like the drink. And I don't know why, because I couldn't really find Sobe drinks anywhere when I was a kid. It was like a really rare treat. Or my mom would never buy them because they were more expensive than every other drink. So we'd see them at gas stations, but like they were never the cheap juice drink. But I just made it my screen name. Just because that's what I did as a kid. So yeah, let's see. A little bit about Mr. Flanagan here. Mr. Chapman. Much of the information regarding Flanagan, Chapman, and Scholl's testimony will be potentially protected attorney-client privilege or private investigator privilege, but such can be waived by the holder of the privilege, Mr. Jason Autry. Thus, the petitioner would request the court to schedule these depositions after a hearing to determine if Jason Autry waives the attorney-client privilege and private investigator privilege. So, I think that's why we're amending it. Get the scheduling. Let's get Autry handled and then deal with this issue. The motion was presented to the court previously, and it was ruled moot because no subpoena had been issued to the state, and the court did not know if Mr. Autry would waive this privilege. A hearing was rescheduled for Mr. Autry on March 18th. However, the state declined to issue any transport order per the writ, and the court did not require the state to do so. Thus, not only is Mr. Autry's testimony in limbo, but so too is everything else that could potentially hinge on Mr. Autry's potential waiver. The court recently advised that it would schedule Mr. Autry's testimony to be with the rest of the trial. Thus, the petitioner requests the court accommodate. Thus, the petitioner seek the following: an order authorizing the issuance of the previously attached subpoenas ducis tecum to those attorneys and Mr. Chapman, for the court to order the hearing for Jason Autry's waiver to take place before such depositions or live testimony, or in the alternative, set the attorney's background private investigator testimony only after Autry either waives privilege or declines to. For the court to order the parties work in good faith, scheduling these depositions, and should the witness elect to testify in person instead of the deposition, then every effort will be made to accommodate their schedule. So there we go. All right. Zach Adams wants to cop Mel instead of compel. Oh no. Motion to cop Mel, production of photos and videos. Again, still on March 7th, going to be on March 7th for a while. Comes now the petitioner wants the court to order the immediate release of the following, to either duplicate or allow for immediate copying. The ATM video that the state argued both defense counsel and the state had, that showed Zach Adams on film the morning of April 13th, 2011. While this evidence did not obviously come out at trial, it was never even referenced by the state and potentially presents a wholly inconsistent fact with the rest of the state's trial. The still frame photo that General Boiano had on his computer screen at oral argument on January 16th, 2025. The photo was seen by Mr. Adams, who recognized the truck as the one he was in at the ATM on the date of April 13th, 2011. The photo is crucial in this case. Rule 16 clearly obligates that this material be provided by the state, which states, we're just going to tell them. We're just going to put the rule here in case you don't know the rule. How did Jennifer Nichols say that? I don't have the rule book in front of me, Mr. Bates. So F, documents and objects. Upon a defendant's request, the state shall permit the defendant to inspect and copy or photograph books, papers, documents, photographs, tangible objects, buildings, or places, or copies or portions thereof, if the item is within the state's possession, custody, or control, and 1, the item is material to preparing the defense, 2, the government intends to use the item in its case in chief at trial, or 3, the item was obtained from or belongs to the defendant. So, counsel for petitioners sent both the following email to the state of Tennessee on February 14th, 2025. Generals Wyrick and Boiano. On the motion to dismiss argument, General Boiano argued in his response with his laptop that had a photo that my client recognizes the truck he was in the morning of April 13th, 2011. Would you be able to provide us with this photo directly? Would the state agree further to voluntarily send us the investigatory subpoena sent to Mr. Mayfield /CB&S Bank? Very yours truly. 5, the state has not provided this discovery, which is somewhat perplexing considering the end of the state's discovery production letter. It states the following: state's reciprocal discovery request. Oh, is this where I was yapping earlier, where I was like, the state always does this. It reminds me of Adrian Love. Gets a ruling from the judge, it's not in their favor, and then they go, well, the defense isn't doing things either. So, state's reciprocal discovery request. The state demands opportunity to inspect and copy all relevant documents and tangible objects over which the defendant exercises any possession, custody, and control, and or which the defendant may attempt to introduce as evidence in this case. Likewise, the state requests opportunity to inspect and copy all reports of examinations and tests related to this case or the defendant. Pursuant to the law and professional courtesy, The state further requests to be informed of other relevant information and documentation of which the defendant or defense counsel is aware. So, yeah. Very truly yours. 6, the petitioner further requests that the petitioner be given leave, if necessary, to amend his pleading based on additional constitutional violations that this photo and video could provide. So there we go. A spicy one here from Doug Bates. And it is dated. It was filed on the 7th, but he wrote it on the 6th. So, oh my goodness. What a time. What a time. Yeah, we need some proofreaders in these filings. But hey, the typos keep us going. The typos are a nice way to pause, laugh a little bit. A break in the monotony. All right, next we've got petitioner's motion to compel the state to comply with Rule 28, Section 5G. So comes now, Zach Adams wants the court to order the state to comply. For cause, the petitioner would show unto the court that the state filed a motion to dismiss and reinforced it in its response to certain allegations in the second amended petition for post-conviction relief. The court took such motion under advisement. The state respectfully failed to comply with Rule 28, Section 5G of the Rule of the Supreme Court, which states that the state shall file a motion to dismiss, which includes facts relied upon to support the motion to raise as a defense. The state has failed to cite any facts in its motion to dismiss. Because what were they saying? Everything. They were like, they're saying we never did this. Zach Adams is saying we, the state, never did this thing, but we want them to prove we didn't do something. Offer strict proof that we didn't do something. But the state has failed to cite any facts in its motion to dismiss upon which the court can dismiss at any time without evidence the requested allegations. The state should not be able to skirt this obligation, even though the court is taking this under advisement. So there we go. They said also. Just sprinkle this one in. All right, next one up is petitioner's motion to determine validity of the state's discovery Rule 16 obligations. So Zach Adams moves this court to determine the validity of the state's discovery response as it relates to the defendant's obligations under Rule 16. And as is capitalized, I don't know, as it relates, while acknowledging that petitioner will voluntarily provide the documents it intends to rely upon at trial. Nevertheless, the state's efforts to circumvent Rule 16 for cause the defendant would show unto the court. So that was an awkward sentence. The petitioner's counsel was appointed in this case, and then ADA Nichols, now Judge Nichols, offered for counsel to come and review her file in Gallatin. Yes, a good old trip to see Jennifer Nichols. After this time, the petitioner's counsel received a better offer. Instead of just reading documents and returning them, Mr. Thompson offered to surrender her file to counsel, which counsel accepted. The state in December provided a purported response, which included the following. And this is their response. This is the state's discovery response in the reference case. If other discoverable information becomes available, it will be provided. The state's demand for notice and reciprocal discovery is found below. So they said that they turned over this whole thing, and we read this notice. The file, all materials in the file previously made available to Douglas Bates by ADA Jennifer Nichols. All materials obtained from Tennessee Administrative Office of the Courts by subpoena relating to the billing records for Jennifer Thompson, Jim Simmons, and Jerry Gonzalez, previously made available to Douglas Bates by ADA Jennifer Nichols, and the Tennessee Comptroller Comprehensive Report on Jennifer Thompson's Administrative Office of Court Billing. That was that, like, Exhibit A, the 300 pages that we're going to try to get to this weekend. All right, so back to the arguments. Johnson v. State makes clear that Rule 28 and TCA 40-30-109 clearly imposes upon the state an affirmative duty to provide discovery materials to the petitioner as part of the post-conviction proceeding. Citing Braylon Bennett v. State, in Johnson, a Public Records Act request contained many documents already supplied to the petitioner. The court did not absolve the state's obligation from providing discovery because it already supplied many of these documents. Thus, in this case, the petitioner would request the state, should it want to act as if it had complied with Rule 16, to provide the petitioner with all documents that was not in Jennifer Thompson or Jim Simmons' file that the state has reviewed or deemed the state to have not complied with Rule 16. So, send it all over. Oh my God, there's so many. We're not even halfway through March 7th yet. All right, so next up we have a petitioner's motion to issue a writ of appearance for inmate John Dylan Adams. So they want Dylan to be able to testify at these hearings. And then they're saying, hey, judge, we want you to find that this inmate's testimony, because he's in custody, is necessary. You can ask the warden, you can compel the warden to supply Dylan Adams. So they're saying it's important. We need Dylan. All right, next up. This will be a good one. I think this will be a good one. We've got petitioner's motion to quash Dr. Katie Spirko's subpoena. Katie Spiro. Comes now the petitioner, by and through counsel, moves this court to quash the subpoena served on Dr. Spirko for at least all portions of the work performed while Dr. Spirko was counsel's agent, and further, for all work while Dr. Spirko has been an agent of Zachary Adams. For cause, counsel shows to the court, Dr. Spirko is not a witness, and her discovery, is not allowed. First and foremost, the subpoena to Dr. Spirko is not truly for her to be a witness at trial. Call it out. In fact, she has the privilege to be exempt from trial and demand a deposition with cost tax to the state of Tennessee. So they cite here statute that says deponents exempt from subpoena to trial, but subject to subpoena by deposition, award of fees and expenses if court grants motion to quash. Deponents exempt from subpoena to trial, but subject to subpoena to a deposition are 6. A practicing physician, physician assistant, advanced practice, registered nurse, psychologist, senior psychological examiner, chiropractor, dentist, or attorney. And 6B, if the court grants a motion to quash a subpoena issued pursuant to subsection A, the court may award the party subpoenaed its reasonable attorney fees and expenses incurred in defending against a subpoena. So they're saying, hey, she's one of these classifications. She was not listed on the state's witness list provided in discovery, nor could she be. What information does she have that she observed in 2011 through July of 2023 before she had ever heard of Zachary Adams? TCA 40-30-109B makes clear. Discovery is not available in a proceeding under this section, except as provided under Rule 16 of the Tennessee Rules of Criminal Procedure. Furthermore, Dr. Spirko is not going to be called as a witness by the state unless they state as officers of the court they are asking her to be an expert in this case to discuss all matters from a neuropsychological perspective as to her opinion on whether Mr. Adams is innocent and or had his constitutional due process rights violated by this court's 2017 trial. It is difficult to contemplate the state seeking such evidence at trial. The state's anticipated, we don't know what we don't know. I can hear that in Amy Wyrick's voice. Well, Your Honor, we need her under subpoena because we don't know what we don't know. Is not grounds to subpoena a witness who had absolutely no factual involvement in this case when it happened from 2011 through 2017 to 2020, when Mr. Adams' motion for new trial was denied. There were 3 umbrellas that are grounds to quash Dr. Spirko's testimony, even if she were under subpoena to be a factual witness for things she observed in 2011 to 2020, or an expert/agent, potential witness / non-testifying agent for the defense. The first umbrella. It is without dispute based on the state's own pleadings in April of 2024 that Dr. Spirko worked as counsel's agent, investigating the constitutional violations and post-conviction relief matters soon after counsel's appointment by this court. Second umbrella. So it's outside the time frame. Proof can be submitted regarding Dr. Spirko's continued work as Zachary Adams' agent from February 2024 until the present. Third umbrella. While perhaps lacking standing, it is helpful for the court to recognize that in the state's April 2024 motion, The state wrote that Dr. Spiro may well have the right to her own personal investigation, as media groups, entertainment programs such as 2020, and podcasters do. This issue is yielded to Dr. Spiro's lawyer, and the court, as petitioner's counsel, maintains strict neutrality on any issue of publicity and will follow applicable guidelines, ethical guidelines, and any orders the court deems necessary to address pretrial publicity of this bench trial. All right, so standing, getting to issues of standing. I think Martina Nem, I'm saying your whole name, I usually just call you Nem. I think the issue here is they don't want her to be under subpoena because they wanted the subpoena to be released. It seems like the defense trial and error podcast, they have some videos about these March events on their channel. But this is where Katie Spiro has to step away. Like, she can't work with the podcast. That's why Doug McClendon is doing the collaborations, and I can't wait for Katie to get on screen. I can't wait for Katie to start doing the productions. But they're really waiting for these hearings for her to be off this witness list. And this subpoena came before the state added her to the witness list. So I think the order of events here, they subpoena her, and they're like subpoenaing her Zoom account that they used to record. They talked about this on the podcast. They got a subpoena for the Zoom account that they record their episodes through. Like, Zoom notified them that there was a subpoena to the account owner. And then now it like stops her in her tracks. Well, we end up hearing this address in the May hearings a little bit. And then it turns out the state says, okay, well, if the subpoena is going to be lifted, then we're going to add her to the witness list finally. So when we're reading this, state didn't say that she would ever be a witness. That's why Doug's like scratching his head, like they don't even have her on the witness list. As soon as the subpoena play doesn't work, they add her to the witness list, and now that effectively keeps her under a sequestration order. So yeah, I think it's something to this, wanting to silence people. Fun times. And then DB says, I think they wanted Dr. Spiro to be their version of Kathy, where she would be exempt from sequestration and helping as the team's investigator. I mean, I can see that, although I'm laughing in the back of my mind, like, I don't want to compare Katie and Kathy. I just don't want to do it. Just don't want to compare them. Can't even picture them in the same role, same position. Shout out to Sunshine, hanging out in the bushes, hopefully not with Kathy. All right, so the standing issue, you guys. This says the defendant submits he has standing to sit under the protection of 2 of the 3 umbrellas Dr. Spiro's work employs. First, as Dr. Spiro was his attorney's agent from the late summer fall of 2023, when work began on this counsel with counsel's appointment, and then from April 2024 until the present, while Dr. Spiro has worked as Zach and Dylan Adams' agent to help them establish their innocence claims using her experience, training, education, and real-world experience. They go through some case law that says Sheets v. Hathcock. So State v. Harris cites this case, which holds that a person cannot challenge a subpoena issued to a third party is incorrect because it fails to recognize that the objecting party may have a recognized legally protectable interest with regard to materials in the hands of a third party. A person who does not have a legally protectable interest in subpoenaed materials has no standing to challenge either the form of the subpoena issued to a third party or the manner in which the subpoena was issued. However, the prevailing rule today is that a person who has a personal right, a privilege, or a proprietary interest in materials subject to a third-party subpoena has standing to challenge the subpoena. And that's Gravel v. United States, which implicitly recognizes a United States Senator's standing by permitting him to move to quash a subpoena issued to an assistant. And they got a bunch of cases, cites within a cite. Thus, we, the Tennessee Supreme Court, adopt this view regarding standing to challenge third-party subpoenas and incorporate it into the law of Tennessee. A person has standing to challenge a subpoena issued to a third party as long as that person asserts a personal right, privilege, or proprietary interest. So this is supporting that Zach Adams has a reason to raise his hand and say, to the subpoena for Katie Spiro. So, concluding here that a person has standing to challenge a subpoena issued to a third party does not mean that the party's challenge will ultimately be successful. That decision will ultimately be based on the substantive merits of the challenge to the subpoena. So then they get into the Rule 16. Assuming arguendo that Dr. Spiro could be a witness called by the state, then none of her materials are subject to disclosure under Rule 16b2 of the Tennessee Rules of Criminal Procedure, which states that, except as to scientific or medical reports, this subdivision does not authorize the discovery or inspection of reports, memoranda, or other internal defense documents made by the defendant or the defendant's attorney or agents in connection with the investigation or defense of the case, or B, a statement made by the defendant to the defendant's agents or attorneys, or statements by actual or prospective state or defense witnesses made to the defendant or the defendant's agents or attorneys. The state has this impossible barrier to these documents and any subpoena requests thereof. And then privilege. So assume further that the state eviscerates the deponent exemption. Post-Conviction Relief Act Section 40-30-101 and Rule 28, and finally Rule 16, then finally standing in the state's way are the recognized privileges cited by Dr. Spiro and one of her attorneys. What? Chat, look at the screen at the next header. It's us. What is going on? That is the header of this section. Oh my goodness. We're gonna have to make this a screen overlay. We're gonna add that to the collection. Oh my goodness, my day is made. I think I have a new favorite header. Okay, let me read. Let me zoom out and let's read. The next header is WTAF. Oh my goodness. Gwennon, if you fall asleep, that is A-okay. I'm not sure my voice is like the lullaby voice, but I hope I can help put you to sleep. Just read you to sleep. The Cat Reads Doug Bates audiobook, Volume 3. I think this is Volume 4 of the motion reading. Volume 4. Yeah, WTFIGO. Oh my goodness. What is going on? What? I'll put up the picture real quick. What? Petitioner's counsel would be remiss if it did not comment on the elephant in the room. Dr. Spiro has drawn the intense ire of the state of Tennessee for her work in this case. Yeah, 1,000,000%. The state had a pending motion to issue protective order against Dr. Spiro that on April 17th, 2024, it voluntarily did not move forward on. The state said it was moot because the video had been released to 2020 by Dr. Spiro already, which the state misunderstood the connection between a protective order that could have been placed on the defendant's produced discovery and matters subject to Freedom of Information Act and sealed by the court, which the video was kept from mandatory disclosure from FOIA requests by media sources. But reading this motion anew, the court should consider the following questions as it navigates what's really going on in this case. 1, why did the state cite cases in which Dr. Spiro was involved in with negative connotations if the sole issue was a reporter/agent's ability to disseminate pretrial evidence? 2, so you don't even need to get into, there's no discretion. It's not a, should we let some people release information and not others, even though their roles might be the exact same. It's just a matter of, can a reporter disseminate this type of information or not? Why on the current subpoena was Dr. Spiro's home address and not office address listed like other subpoenas were? Do you think that was an oversight? Do you think that was an oversight, chat? And this is the same prosecution team that brought a witness intimidation charge against Zachary Adams because he allegedly asked his brother to go allegedly asked another inmate to go threaten his brother. But here we are. Why did the state say in a Zoom conference it might need to subpoena Dana McClendon after an apparent, quote, podcast was revealed? It appears to counsel for the petitioner that all of this use of the subpoena power, limited by Rule 28, is best understood as something more than legitimate Rule 28 and Rule 16 discovery to bring witnesses to the post-conviction relief for their factual knowledge or expert assistance of matters that took place between 2011 and 2020. Whatever the answer is, it is a distraction on the fact-finding on the issues that took place from 2011 to 2020. For the foregoing reasons, petitioners ask the court to quash the subpoena, or in the alternative, for measures put in place to ensure that no privilege information is disseminated, and further, no matters outside Rule 16 are provided, and only provided when the state complies with Rule 16's requirements. Respectfully submitted. And I'm zoomed in, but I wish this signature block was like giant. Like, I'm super respectfully submitting this one. All right, so there we go. I think that was a good read. I like that one. Where was that? Let me highlight that one in case we need to pull it up in the future. So I'll highlight all of these in purple. And then I want to highlight that, the petitioner's response. Oh, this one. The one that I recommended if you guys missed it earlier. You guys go and either re-listen to or reread. All right, next we have petitioner's motion to set expedited hearing via Zoom on pre-hearing matters. Let me close all these other tabs. All right, so they want a expedited Zoom hearing before March 21st to address any necessary matters before the March 21st hearing, which specifically includes the petitioner's motion to enter order approving communications with Jason Autry. All right, next. Oh, this is a long one. All right. So this is this about Subpoena Gate? This is Subpoena Gate. Let's read about Subpoena Gate. All right, so petitioner's motion to show good cause to release the investigative subpoena and affidavit under TCA 40-17-123. So they're moving this court to order the court to find good cause to release this investigative subpoena and supporting affidavit to Mr. Mayfield and or CB&S Community South Bank. For cause, the petitioner would show unto the court, 1, Mr. Adams was with Mr. Austin on April 13th, 2011, and not committing the crimes for which he was convicted. 2, certain alibi evidence was gathered by his defense counsel in part, and other evidence was not procured. 3, one such crucial piece of evidence was the ATM video from Community South Bank that showed where they were and when they were there. Upon information and belief, such a video will establish the impossibility of the state's evidence in this case. 4, Mr. Adams' legal team attempted to gather this video from CB&S Bank, which bought Community South Bank, with the attached subpoena, see Exhibit 1. In response to this subpoena, Ms. Myra Taylor provided a letter that stated, upon diligent search of our records, no videos were found for the ATM withdrawal at Community South Parsons and Parsons, Tennessee on April 13th, 2011. 5, counsel for petitioner has traveled upon the theory that thus no video existed because of this response. However, General Boiano has advised the state that the state has it, and petitioner's counsel trusts the general completely at his word. A separate motion is sought to recover this video. For reasons unknown to petitioner, the state of Tennessee subpoenaed without notice to petitioner the entire ATM found by Mr. Mayfield. Oh, they got the whole ATM machine. I thought they just took like the device from inside it. This is so important. Let me stop laughing. There's a lot in this paragraph. For reasons unknown to the petitioner, the state of Tennessee subpoenaed without notice to the petitioner the entire ATM found by Mr. Mayfield with CB&S Bank after Mr. Mayfield discussed matters with counsel and Mr. Adams' agent, Dr. Spiro. So one could easily infer that the state of Tennessee was aware Dr. Katie Spiro was speaking to this manager, and they said, oh, run and get there first. And remember, they're going to ask when they bring the subpoena to Mr. Mayfield, they're going to include a portion that requests that they do not discuss that they were subpoenaed with anybody else. Act like this subpoena doesn't exist. It's the Inspector Gadget self-destructing note. The reason such approach was peculiar is apparently the state already had its contents, thus it seems to be carrying the coals to Newcastle. So you don't want somebody else to have their own opportunity to access it. If you already have it, why are you running to get it? And why are you only running to get it after you get word that Dr. Katie Spiro is trying to obtain it? On January 16th, 2025, the state acknowledged that it issued a subpoena through law enforcement, presumably through TCA 40-17-123. TCA 40-17-123, and I think we have a footnote, or maybe this is just a mark on the paper. Okay. Subsection E, the affidavit filed in support of any request for the issuance of a subpoena pursuant to this section shall be filed with and maintained by the court. If a subpoena is issued as a result of an affidavit, the affidavit shall be kept under seal by the judge until a copy is requested by the District Attorney General. Criminal charges are filed in the case, or the affidavit is ordered released by a court of record for good cause. So this is the maneuver that, even though you know that the defense wants a judicial subpoena in a separate motion to obtain this information, you open up this other mechanism, this other investigation, and if under this rule, this would shelter what you're doing from being discoverable by the defense. You wouldn't have to necessarily inform somebody else. So this says that the affidavit upon which the subpoena was issued can be issued for good cause. The court seemed to imply on January 16th that it would have been prudent to provide petitioner with a copy of the subpoena. The state has still not provided the subpoena and supporting affidavit. To be clear, and we're going to read this, but before we get there, I think Trial and Error podcast, either they had episodes or maybe it was like, Dana might have said it also when we did the collab. I can't remember. But this January 16th hearing, Bradbury seemed visibly pissed when he heard what the state was doing. And I can picture it. And I wish there was video of that hearing. And I wish we could watch it together. Yeah, EC, I think something along those lines too. Kathy Ferguson heard that jail call and put 2 and 2 together. Just nuts. So if you guys remember, there was, and there's more than one, but there's snippets of a call that Trial and Error podcast has uploaded where Zachary Adams is describing driving backwards through the ATM. A second thing that I think is critical is I just have this gut feeling that early on, Terry Dykes saw this footage. Like, not like a random still image, but actually saw the footage. And he didn't realize when he was looking at it of what extent the paramount importance this ATM footage would play. I don't think he realized that Zach Adams' car was going through that ATM footage. But I think he had the sonic information and he was like, all right, these guys were in Parsons. I think he concluded without comprehending what was in that video that he remembers seeing but didn't remember identifying specific vehicles within it. He said the other things looked like enough to be an alibi. And I think his presentation might have tipped the rest of the TBI off and they said, fuck, we got to get rid of that. ATM video. That's my personal theory on what went down. Like, Terry Dykes was right there and didn't connect the dots with that ATM video and the other Parsons, Tennessee evidence that to him was enough for clear and convincing alibi standard, right? And they're like, no, you didn't alibi him, and they snatched something away, and now we're watching the state fight to prevent access to Zachary Adams' team to this very thing. That's what I think happened. Anyway, they say that the court seemed to imply on January 16th that it would have been prudent, and that now the state still has not provided the subpoena. We're on March 7th. The state still has not provided the subpoena and supporting affidavit. To be clear, since January 16th, 2025, the state has A, objected to counsel meeting with his client over Zoom. B, stated to the court it might have to issue a subpoena to Mr. McClendon. Or words to this effect, a transcript is forthcoming. 3, issued a subpoena to Dr. Spiro. Despite stating in prior pleadings she acted as an agent from 2023 until February 2024. 4, advised the court they would not transport Jason Autry to any trial because he was too dangerous to transport, despite the prosecutors spending days with Mr. Autry preparing for the 2017 trial. But at no time in the past, at no time in the past almost 2 months could they provide the petitioner with this subpoena's affidavit wherein presumably law enforcement advised they were investigating a crime. The same crime the state continually advises the court is settled because of a jury verdict. Petitioner submits the above established many things, the least of which is good cause to release the affidavit and subpoena pursuant to TCA 40-17-123. Respectfully submitted, Doug Bates, and remember, all of this was under this great header. Oh wait, no, this is a different petition. I'm getting lost. But in my mind, this is all what is going on. So we've got this copy here. So April 7th, 2016. So remember, this was their attempt. And this is critical because the state is also trying to argue, hey, this whole post-conviction relief petition's garbage because you guys have had an opportunity to raise this stuff. There's nothing new here. You guys are just whining and crying, but it's done. The judgment is final, and there's no reasonable opportunity for you to reopen the door and fight for a new trial. But hello, we have this evidence here that Zach's trial counsel, this is April 7th, 2016. We have a response here from Myra Taylor that was referenced above, addressed to Jim Simmons. And she says, look, upon diligent search of our records, no videos were found for the ATM withdrawal at Parsons on April 13th, 2011. So it makes sense that trial counsel would think, hey, we don't have another way to access this thing, or maybe it doesn't exist. Then we see it on the screen of a prosecutor at a January hearing. Oops. All right, so, and these are billable hours, so it looks like they're... All right, I've searched our records. Below is a breakdown of the charge for this research. So it's billable hours to do this work to search, submitted by Myra Taylor. So she spent an hour, and she had to purchase a statement. So she spent an hour looking for this information. And is this where Shane Austin... a deposit here on the 11th. All right, now here we have to the custodian of records from Jim Simmons. March 29th, 2016 is the attached subpoena ducis tecum. So they want these records. And they were looking for the ATM withdrawal and point of sales purchase at a Shell station and point of sales purchase at MAPCO. All right, and then they have all these other transactions. So I think the Shell station and then the Sonic, and then it goes on to other days. It just happens to show us on a page. Although I don't know, is it possible that some of these posted dates, like when like this could be the completed purchase, but it was initiated on the 13th, but it doesn't actually post until the 14th. So maybe these are also relevant, some of them. And then the deposit. So there you go. All right, next we have motion requesting the court to appoint counsel for Jason Autry. Oh, and this one's long. So they're probably going to have a reason. All right, so State of Tennessee wants the court to appoint an attorney to represent Jason Autry for the limited purpose of the above referenced case. They're going to recite here Decatur County Grand Jury indicted Zach Adams, Dylan Adams, and Jason Autry on May 19th, 2015 for the rape, murder, and kidnapping of Holly Bobo. The state of Tennessee tried petitioner in Horne County in September 2017. Autry testified for the state at the trial. Petitioner was convicted on all counts by the jury and sentenced by the Honorable Creed McGinley to life without the possibility of parole. On September 14th, 2020, inmate Autry, represented at the time by Michael Scholl, pled guilty before Judge McGinley to reduce charges in light of his testimony against petitioner. They attached the transcript here. He was released from custody following his plea. On December 2nd, 2020, inmate Autry was arrested on a gun charge. Well, dang, that was pretty fast. He was arrested on a gun charge in Benton County, Tennessee, and prosecuted by both the federal government and state of Tennessee. Inmate Autry pled guilty, represented at the time by Claiborne Ferguson, in federal court on November of 2022, to being a convicted felon in possession of a Marlin .30-30 caliber rifle, a Smith & Wesson 9mm handgun, and several rounds of .30-30 Winchester ammunition. As part of the plea agreement, inmate Autry stipulated that before he committed the offenses charged in the federal indictment, he had at least 3 previous convictions for violent felonies, as defined in the section 924 2B, which were committed on occasions different from one another, so different transactions. The United States Attorney's Office for the Western District of Tennessee filed a motion requesting the Western District Court judge upwardly depart from the sentencing guidelines due to inmate Autry's lengthy, violent criminal history. Between inmate Autry's federal guilty plea and sentencing, 3 different attorneys were appointed to represent him. 2 of them, Mike Weinman and Kevin Whitmore, filed on separate occasion motions requesting the federal judge downwardly depart from the sentencing guidelines. Each cited as support for their request inmate Autry's testimony at petitioner's trial and assistance to the state of Tennessee. The dates of these filings and the attorneys who prepared them are as follows. August 22nd, 2023, through attorney Mike Weinman. October 27th, 2023, through attorney Mike Weinman. And then June 25th, 2024, through attorney Kevin Whitmore. I was going to say, they're going to couch this around what's right here, guys, the recantation. So they're going to say it was in his interest or he's out of spite. That's the only reason he told Katie Spiro what he told them. On December 22nd, 2023, so right in between this timeline here, Katie Spiro, working on behalf of petitioner and petitioner's attorney in various capacities, video recorded a conversation in federal prison with inmate Autry about his testimony during petitioner's trial that was provided by Spiro to ABC News' 2020. This video is the foundation of petitioner's pleadings before the court. Inmate Autry's attorney at the time of the recording and distribution, Mike Weinman, did not authorize the recording, nor was he made aware of it until after the fact. These actions by attorney Bates and Katie Spiro forced attorney Weinman to file a motion to withdraw as counsel with the U.S. District Court for the Western District of Tennessee. The court granted Weinman's request and appointed new counsel, Kevin Whitmore, to represent inmate Autry. Well, and why is this? Because it wouldn't be proper for Mike to continue, I'm not trying to cross his name out, I'm trying to underline, it wouldn't be proper for him to continue the representations requesting a downward departure for his cooperation with the state if he had now learned that his own client is saying that same cooperation was an entire fabrication. So he's got to go. He'd either have to change his whole representations to the court, or he can make a kind of dirty exit. So, and I don't think they're framing this as being helpful to the state's position against Doug Bates and Katie Spiro, but I think this is more reflective on that attorney put weight into Jason's recantation. I don't think that this order of events, the way I read them, helps the state, but they're framing it that way. They have a different reading than I do. Anyway, they say that the court granted Weinman's request and appointed new counsel, Kevin Whitmore, to represent inmate Autry. The state of Tennessee is aware through recorded jail calls of 3 statements made by inmate Autry in reference to his recorded conversations with Spiro that are relevant to this motion. All right, this is interesting. 1, inmate Autry advised Skylar Pinkley on January 3rd, 2024. Is this like the girl that's not his wife? That he was high on drugs while meeting with Spiro and being recorded. Specifically, inmate Autry states the following about Spiro. Jason says, she looked at me and said, "Can I ask you a question?" And I said, "What's that?" She said, "Are you high?" I sat there for a second. I said, "Yeah." I said, "If this is going to hinder you, you need to leave. You know what I mean?" Am I being gaslit by this? Because I don't remember this from the recanting interview. I don't remember that part. I remember her asking, like, if he was good to have this conversation. I don't know how to erase this. Well, that might just be stuck on the screen. So Skylar says, right. Jason says, yeah. Skylar says, well, she told me that. Jason Autry, yeah, I don't know if that played a part in the deposition or not. Skylar says, no, she said you done fine. Jason, she got what she wanted, didn't she? 2, inmate Autry advised his mother on January 31st, 2024. They going to fuck me in federal court. I'm fucking them in state court. 3, inmate Autry advised his mother on February 4th, 2024. They trying to give me 20-something years in the federal government. I gotta fight back. That's the only thing I've got to fight with. His recanting wouldn't help him, though. They're using his recanting interview. His attorney walked away. On April 5th, 2024, Katie Spiro notified former Assistant District Attorney General Jennifer Nichols that Dana McClendon would be representing Katie Spiro. Attorney McClendon was copied on said email. On April 8th, 2024, Spiro attempted to schedule another meeting with inmate Autry at the same federal facility. She did this via an email on which Attorney McClendon was copied. She inquired whether the prison had a notary on site or whether she should bring one along. It is the state's belief that Ms. Spiro intended to obtain an affidavit from inmate Autry, casting doubt on his trial testimony. Prison officials declined her request to meet with inmate Autry. Neither inmate Autry's attorney of record nor Petitioner Adams' attorney were copied on her email. On April 15th, 2024, Attorney McClendon filed notice with this court that he represented Katie Spiro. Inmate Autry was sentenced in federal court, represented at this time by Kevin Whitmore, on June 25th, 2024, and sentenced to 279 months, so 23 years. Autry has appealed his sentence to the Sixth Circuit and is represented as of this filing by Elizabeth Eric, a federal appointed appellate attorney. The state has been advised by Attorney Eric that her representation of inmate Autry is limited solely to the appeal of his federal conviction. Inmate Autry entered a guilty plea to the state gun charges in Benton County Circuit Court on July 19th, 2024, represented by Billy Rowe, to run concurrent with his parallel federal prosecution. Petitioner is hopeful that inmate Autry will appear in Hardin County Circuit Court on his behalf and testify contrary to his trial testimony, thereby casting doubt on petitioner's guilt. For the reasons stated above, the state requests that in the interest of justice, counsel be appointed to inmate Autry to advise him of his rights under the Fifth Amendment and advise him of any possible consequences should he testify in the case at bar. Now, this is a legitimate right. This is legitimately something he should be aware of. But at the same time, it seems like the only interest the state is interested in this is to make sure he's aware of the pressure and exposure, and thus hint strongly and put it top of mind why it would be in Jason's best interest to not come testify at the petitioner's call, which would be beneficial to the state. That's the only reason they're concerned about his possible exposure here. Inmate Autry is currently housed in federal custody in Kentucky. In the interest, because he's too dangerous to transport. He's too dangerous to transport, but we're so worried about his rights. So worried about the rights. Okay, I'm looking over here, and DB says Eric begged the court a few months later to be removed. Yeah, and DB, I agree. I just don't see how this would... Him recanting with Katie Spiro, I don't see how that would have been... If you're trying to fight for a downward departure, you only have to lose by saying those things to Katie, knowing that it's going to be recorded. So I also don't... I don't know. This to me right here, this bit, if this is going to hinder you, that's awareness right there that Katie had a purpose. He was aware of what Katie would do with anything he said here. It's not like he was misguided, that Katie was looking to use this information to, in some way or form, in relation to ongoing matters relating to the Holly Bobo case. But yeah, this is them trying to frame it any other way. And if I was stupid, I could see myself taking it at face value. Let's see. Where were we? Same email. All right. He enters a guilty plea. So Eric's like, hey, I am only appointed to represent Autry in the capacity of that appeal for the federal conviction. Inmate Autry entered a guilty plea to the state gun charges in Benton County on July 19th, 2024, represented by Billy Rowe. Petitioner's hopeful. We want him to be aware of the Fifth Amendment rights in the interest of judicial economy and the victim's Bill of Rights. The state requests that if an attorney is appointed, he or she be advised that meeting with inmate Autry can be accomplished in person or via video conferencing to make the initial. So we can make that happen. We'll make sure we facilitate this. But we won't do this for the petitioner. Oh man. It's just really funny to watch these motions come in back to back. Just a hot mess. No, I think Factual Lie's birthday is January 3rd. But Aaron's is Adventure in Aaron is the 28th, so that's Sunday. So all of our pregame for the hearings will also be for Adventure Aaron's birthday. We've got, let's see, he's going to be subject to cross-examination, an actual cross-examination this time. Given the conflict petitioner's attorneys have in providing objective, unbiased advice to inmate Autry, the state requests that petitioner's attorneys be precluded from any contact with inmate Autry until such time as an independent, objective, unbiased attorney can articulate to inmate Autry the decision before him, the consequences of his decision, and report such back to this court. And I'd also say this could also be a delay move, like put time before what was the hearing for March 21st? I think March 21st. I forget. But March something is the next hearing. So that was Amy Wyrick. All right, we still got a few more for March 17th. We have a state's motion to clarify the record. Oh my God, it's 39 pages. Okay, there's a lot of exhibits. Okay. I'm going to try to get through March 7th, but 39 pages is a lot, so we'll see. So they want to clarify the record. The state wants the record clarified relative to the representation of Katie Spiro. So comes now the state of Tennessee. Tell us who Katie is. Define it for the court. Is she an agent? Is she a forensic psychologist? What is she doing? Katie Spiro filed a declaration with this court along with her curriculum vitae on January 22nd, 2024. In said declaration, Spiro outlined her work in neuropsychology and false confessions and advised that attorney Douglas Bates discussed retaining her to review any particular evidence regarding inmate Autry's testimony and provide appropriate perspective. This filing came shortly after Spiro, working on behalf of petitioner and petitioner's attorney, video recorded a conversation in a federal prison with inmate Autry about his testimony during petitioner's trial that was provided by Spiro to ABC News 2020. The date of this video recording was December 22nd, 2023. On April 1st, 2024, Spiro emailed the Tennessee Department of Corrections to schedule a non-recorded video conference with petitioner through attorney Dana McClendon. Attorney Dana was copied on the email. Upon information and belief, to accommodate Spiro's request, Tennessee Department of Corrections required the Tennessee bar number of attorney McClendon, and that was provided by Spiro. Attorney Bates, counsel of record for petitioner, was not included in these communications. On April 5th, 2024, Spiro conducted and recorded her requested video conference with petitioner. Upon information and belief, ABC News 2020 participated in said video conference. Also on April 5th, 2024, Spiro emailed former Assistant District Attorney General Jennifer Nichols, advising her that attorney McClendon represented Spiro. McClendon was copied on this email. On April 8th, 2024, Spiro attempted to schedule another meeting with inmate Autry at the same federal facility. She did this via an email on which attorney McClendon was copied. She inquired whether the prison had a notary on site or whether she should bring one along. It is the state's belief that Spiro intended to obtain an affidavit from inmate Autry, casting doubt on his trial testimony. Yeah, upon information and belief, it is my opinion that the state and each of these Department of Corrections, right? It's not limited to just one facility. But the state has the pull with these facilities. That seems to be able to be a moving hand in ways that a regular person wouldn't be able to move their hands. She said, "Hi, Jennifer. It's me. Let me know if you have a problem with any of this. Thank you." Oh, my goodness. On April 12th, 2024, the state of Tennessee requested this court issue a subpoena for Spiro to appear in court with certain information. On April 15th, attorney McClendon filed with this court notice of representation of Spiro. The state's motion, well, I actually think this is helpful to Spiro. Because if he's not related to this, he's not part of this case filing, then what she's doing here, especially if 2020 was present, like, this is weird. Like, are we taking issue with ABC News 2020 being part of this video conference? Like, do we have motions for them? Because as far as I know, if this relates to some of the stuff that's on the podcast, I mean, I don't really see what the issue, like, there's no other separate filing or some type of injunction relating to something that involved petitioner and 2020. So anyway, and then McClendon wasn't really, he wasn't even part of this case until April 15th. The state's motion referenced in paragraph 7 above was removed from the docket by the state on June 14th, 2024. Okay, wait, so April. Let me just look and see if that was actually removed from the page. So it might not be on the docket, but I think it was downloadable. We had read it. And is this where she was claimed? This is the 56-page document, I think. Is this what the text message is? With Janet Britt, where she was supposedly threatening Janet Britt. I'm glad we got to read that. But okay, they're representing here that it ended up getting taken down from the docket. On February 9th, 2025. Oh no! The podcast. Spirko and attorney McClendon began advertising their upcoming podcast regarding the case at bar on various social media sites. These promotions continue as of the date of this filing. Well, does this tell you why they're freaking out about Katie Spiro so much in this March 7th, 2025 time period? On Friday, February 14th, 2025, the state of Tennessee issued a subpoena ducis tecum for Spirko to provide documents and other information to this court. On February 20th, 2025, attorney Kaylee Turrent filed a motion to quash the subpoena issued to Spirko. On February 25th, 2025, attorney McClendon filed an agreed order of substitution of counsel relative to Katie Spirko. On February 26, 2025, attorney McClendon filed another agreed order of substitution of counsel relative to Katie Spirko. On March 3, 2025, attorney McClendon filed a supplemental motion for substitution of counsel and declaration of Dana McClendon. Now, if you notice, and I'm not saying it's not part of the record necessarily, but it wasn't on the media page with all of the filings. We don't have any of that. So we can't take a look at any of that. Otherwise, we would have read all of these things from the beginning of the stream, because that's the time period we're covering, is February and March 2025. Based upon information and emails the state has been provided by the Tennessee Department of Corrections and the U.S. Marshal Service. Oh, so the U.S. Marshal Service is reputable now? They don't just guard vaccines or whatever Brett Booth said? We take issues with paragraphs 9 and 10 in attorney McClendon's declaration and ask that the record be made clear. So they don't want to spell it out here. And then this, I guess, might be under seal because we can't see it. But they won't spell it out. But I'm assuming it might be, hey, I'm Dr. Katie Spiro and I'm a forensic psychologist and I'm interested in speaking with Jason Autry. And they're taking issue with her characterizing herself that way. Oh, good times. All right, so they attached some emails here. Oh, this is the declaration. Okay, so cool, we get to see them. I spoke too soon. So they are not listed on the docket anymore, but they are part of this exhibit. So this is the old one, actually. I think we read this one. So we read this when we read through the 2024 stuff. She's worked with, I think we did. Right? Maybe we just heard about it. No, I don't see this in here. And that makes sense because that looks kind of new. So let's read this. All right. Licensed neuropsychologist who practices in Tennessee. CV is attached. I've worked in civil and criminal cases ranging from parental evaluations, Rule 35 psychological assessments, family coordinator, and in other criminal cases ranging from diminished capacity and memory issues to forensic evaluations for defenses of not guilty by reason of insanity. And potential mitigating circumstances related to a defendant's neuropsychological status. I've worked with Douglas Bates IV in a variety of cases beginning in 2020. I have taken positions to which his client was bitterly opposed. I have taken positions congruent with his client's preferred outcomes. So I have not always agreed. I am not just a hired gun. Like, his clients, I've made determinations about his clients that did not help their appellate issues, or maybe they were at the trial level, who knows, but they were not what the defendant wanted. I'm not a hired gun. In August of 2023, he contacted me to see if I was interested in possibly being retained in the Zach Adams case to review any particular evidence regarding Jason Autry's testimony and provide appropriate perspective. I have watched the publicly available portions of Zach Adams' criminal trial on YouTube and have reviewed an abundance of evidence pertaining to this case. I have interviewed multiple parties related to this case. I interviewed Zach Adams on December 1st, 2023, in person where he is currently incarcerated. I have interviewed James and Rita Austin, parents of deceased co-defendant Shane Austin. I have interviewed Lisa Carroll, a resident of the Parson area in Tennessee, who advised me that on the morning of April 13th, 2011, at approximately 7:50 a.m., she encountered Terry Britt. I think this was included in the petition. Right? This is where I think her affidavit was included in one of the petitions. She interviewed Janet Britt for an hour, other neighbors, Jason Autry. He just added Holly to it. Yeah, so we did read this. It just wasn't a standalone docket entry. All right. Maybe I don't really remember all of this. General Nichols was the boss of it all. I remember that. And then he interviewed a couple close acquaintances of Jason Autry across several occasions who attest to previous disclosures made by Autry regarding the pressure he was under to provide false testimony in support of the state's case against Zach Adams. One of these acquaintances described a confidential report regarding the analysis of some biological evidence in this case, which was shown to this acquaintance by Mr. Autry during a correctional center visit. So he had it. It wasn't just like his attorney would bring the case file and had to leave with it like other defendants are subject to. He was able to just sit there with this stuff and bring it to show other people. Per the acquaintance, Mr. Autry brought the report with him to the visit from a box of evidence he was reportedly provided by his attorney. The description of this evidence was consistent with my review of the original documentation, which to my knowledge was never made publicly available. Mr. Autry's detailed account of his falsified testimony includes several additional details that I have independently verified through corroborating interviews and/or objective evidence in this case. All right, and then emails. So April 1st, 2024, and let's scroll to the bottom for, oh, okay, that's the whole thing. So Katie Spiro, let's see. Hi, Misty. I am writing to request your assistance in setting up a non-recorded virtual/video conference meeting with inmate Zachary Adams for this Friday, April 5th. Any time should work. If Friday is not possible for any reason, I could do Thursday, April 4th at or after 2 p.m. as an alternate. This meeting will be myself, Dr. Katie Spiro, through attorney Dana McClendon, who CC'd. I believe you should already have my driver's license on file, but I'm happy to resend it if needed. Please let me know if you require anything further to arrange this meeting, and thank you so much for the assistance. Exhibit C is the email to Jennifer Nichols. Oh no, it's from Jennifer Nichols to Chris Boiano. It says, FYI. So Jennifer Nichols is forwarding this to Boiano. And what she's forwarding is this email from Katie to Jennifer with Dana McClendon CC'd, and it says, Introduction. Good afternoon, Miss Nichols. I believe my name has come up in connection with Zach Adams' recent filings. I wanted to reach out directly to make sure you have my direct contact, as well as that of my attorney, CC'd, in case you need to speak with me or want to speak with me. Please do not hesitate to reach out at any point. If it would be helpful to you, I am happy to come meet with you in person. Thank you. Oh, she sounds so sneaky. Isn't this the type of thing that somebody who was trying to hide something would voluntarily offer to sit down and do? Oh my goodness. All right, next is, Daryl Clear on behalf of a visitation office for Shelby County, Tennessee, sent on April 8th, 2024 to Katie Spiro and the visitation office with Dana CC'd. It's an inmate visitation request, a response. We have a notary on staff. Please give us 48 to 72 hours and I will respond to this email. Thank you. And it says subject, inmate visitation question, Jason Autry. They had asked what was the name, and this looks like the initial correspondence was, "Hey, good morning. I'm needing to set up a visitation with an inmate at the Shelby County Penal Farm, and I'm wondering whether you have a notary service available at the facility, or if I would need to bring someone with me to the visit. I'm hoping to be able to schedule the visit for this Wednesday at noon in case that makes a difference. Thank you." So it's like, you know, the state is like, initially, "Oh my God, dismiss this. Nothing's notarized. These are just affidavits. Nobody's, some of them aren't even providing affidavits. It's not sworn under penalty of perjury." But then, "Hey, well, we want a notary there in case we need anything signed off on." "Oh, we have a notary." And then prosecutors communicate with Department of Corrections, and suddenly they nix this meeting, even though it seems like they have notaries available. So it's not like it's not an allowable practice. And, "Oh no, they want something notarized." And then you're also arguing, "Well, hey, you don't have things notarized, so you can't use anything from Jason Autry." This is all panic. This is all a panic play. And for what it's worth, the state is trying to utilize all of the available cards, even though I think they're coloring outside of the lines to do so. But like, this is the little teeny granular nuanced fights that you have to fight to have any chance of getting anywhere with a post-conviction relief claim. You have to go through these stupid hoops. And the state always has a better line of communication to things like, jails, prison facilities, wardens. All right, next exhibit. April 12th, 2024. This is their motion to issue the subpoena and protective order against Katie Spiro. Next is Dana McClendon's notice of appearance. And he requests that the pending motions filed by the state be set on a date and time convenient to the parties, but not on or before May 3rd, 2024. Next is subpoena to Katie Spiro for document production. I think we saw all that stuff. Bring everything. Bring all recordings. Bring all writings. Bring all notes. And then motion to quash. I don't know if we read this one. So this says, "Comes now counsel Kaylee J. Turin files this motion within the required time period of production. We want the court to quash or in the alternative stay the subpoena." And then here they're citing 24-1-208. That persons gathering information for publication or broadcast disclosure states, A person engaged in gathering information for publication or broadcast connected with or employed by the news media or press, or who is independently engaged in gathering information for publication or broadcast, shall not be required by a court, a grand jury, the General Assembly, or any administrative body to disclose before the General Assembly or any Tennessee court, grand jury, agency, department, or commission any information or the source of any information procured for publication or broadcast. B. Subsection A shall not apply with respect to the source of any allegedly defamatory information in any case where the defendant in a civil action for defamation asserts a defense based on the source of such information. C1. Any person seeking information or the source thereof protected under this section may apply for an order divesting such protection. Such application shall be made to the judge of the court having jurisdiction over the hearing, action, or other proceeding in which the information is sought. 2. Application shall be granted only if the court, after hearing the party, determines that the person seeking the information has shown by clear and convincing evidence that there is probable cause to believe that the person from whom the information is sought has information which is clearly relevant to specific probable violation of law. The person has demonstrated that the information sought cannot reasonably be obtained by alternative means. The person has demonstrated a compelling and overriding public interest of the people of the state of Tennessee in the information. I'm interested. I'm not in Tennessee, but I'm interested in the information, so I don't know about my fellow Tennesseans. 3A. Any order of the trial court may be appealed to the Court of Appeals in the same manner as other civil cases. The Court of Appeals shall make an independent determination of the applicability of the standards in the subsection C to the facts in the record, and shall not accord a presumption of correctness to the trial court's findings. The execution of, or any proceeding to enforce a judgment divesting the protection of this section, shall be stayed pending appeal upon the timely filing of a notice of appeal in accordance with Rule 3 of the Tennessee Rules of Appellate Procedure, and the appeal shall be expedited upon the docket of the Court of Appeals, upon the application of either party. And C, any order of the Court of Appeals may be appealed to the Supreme Court of Tennessee as provided by law. So under this, communication between attorney and private detective privilege states, communication between an attorney and a private detective or investigator hired by such attorney, while acting in their respective professional capacities, shall be privileged communications. The state has not proven that Dr. Spiro has any information that would not be covered under journalistic privilege or as an investigator in this matter. Therefore, we would request the subpoena ducis tecum that was requested on February 7th, 2025, be quashed or, in the alternative, stayed immediately. And this is a agreed order of substitution of counsel. So Turin was entering appearance, substituting for Dana McClendon. All right, okay, I think we have some statements from Dana. Maybe this is what... I wonder if this is what was being cited by the state earlier then. So I don't see this filed on the docket, but we're getting it here. So declaration of Dana McClendon, supplemental motion for substitution of counsel. So under penalty of perjury, the undersigned counsel states as follows in support of the motion to withdraw. My name is Dana C. McClendon III. I am an attorney licensed to practice law in Tennessee. I've been an attorney in good standing in the state and federal courts of this state since 1993. My initial involvement in this case arose because the state of Tennessee filed a motion on April 12, 2024, to subpoena Dr. Katie Spiro and subject her to a protective order. I filed a notice of appearance on behalf of Dr. Spiro on April 15, 2024. The state filed on June 20th, 2024, a notice striking the motion to subpoena Dr. Spiro. That appeared to resolve any reason Dr. Spiro might need my assistance in this case. Until I filed the agreed order to substitute counsel for Dr. Spiro in late February 2025, I had filed nothing else in this case. It is my understanding some confusion has arisen about my role in this case. I have never spoken to Zach Adams. I have never participated in any electronic communication with Zach Adams. I have never represented to anyone that I represent Zach Adams. It is my belief that Special Prosecutor Nichols was actually aware, not later than April 5th, 2024, that my role in this case was limited to representing Dr. Spiro. I am aware, and I think they were taking issue, we'll go back up to the motion, but I think it was lines 7 and 8 that they were taking issue with, but we'll put a pin in that. I am aware of communications in April 2024 from Mr. Bates and Dr. Spiro to Special Prosecutor Nichols and Department of Correction representatives resolving any such a misunderstanding, if indeed any ever existed. I am aware, or I'm not aware? If any? Specifically, I believe that not later than April 5th, 2024, my role in this case as Dr. Spiro's attorney, and the fact of Mr. Bates' continuing representation of Zach Adams, and the difference between who represented Dr. Spiro and who represented Zach Adams, was made clear by electronic communication to Special Prosecutor Nichols and to officials with the Tennessee Department of Corrections. Dr. Spiro and I subsequently decided to produce a podcast covering the captioned case. Mindful of my obligations under Rule 1.16 and 3.6 of the Rules of Professional Conduct, it is appropriate for me to withdraw as counsel for Dr. Spiro. And they're saying that this was set to be heard on March 7th. Let's see. And this was sent on the 3rd day of March. So let's roll back up. What lines did they have issue with? Maybe it was 10 and 11 and not 7 and 8 or whatever I thought it was. All right, so they have an issue with 9 and 10 in the declaration. And they say, based upon information and emails the state has been provided by TDOC and the U.S. Marshal Service, we take issue with paragraphs 9 and 10. But notice they don't just cite it here. They don't just provide the information. Let's see. So 9 and 10 would be, I have never represented to anyone that I represent Zach Adams. And 10 is my belief that Special Prosecutor Nichols was actually aware, not later than April 5th, 2024, that my role in this case was limited to representing Dr. Spiro. So are they relying on these emails where he's CC'd? To make some argument for them, like the exhibits should speak for themselves. Notice of appearance on behalf of Katie Spiro. I am needing to set up a visitation, so Katie's using I language, even though Dana's CC'd. It says, good afternoon, Miss Nichols. I believe my name has come up in connection with Zach Adams' recent filings. I wanted to reach out directly to make sure you have my direct contact as well as that as my attorney, CC'd in case you would want to speak with me. How do these emails support the state's argument that Dana's being misleading with paragraphs 9 and 10? What is she talking about? What is Amy Wyrick talking about? How does she disagree with these? My goodness. And I see, okay, wait, well, maybe we'll have some clear answers to answer my confusion. Shout out to Just Shamrock. Good to see you. Hope you're doing well. I also saw some guy with cancer has his birthday tomorrow, so we've got to have a party tomorrow for you and a party on Sunday for Adventuring. That'll be a fun time. If you don't hang out with us tomorrow, I hope you have a great one. That's not me saying you have to hang out with us tomorrow. I'm just going to say it out loud tomorrow. All right, so Trial and Error Podcast, good to see you guys. Always has some context for us. So Mike Weinman represented Terry Britt in his federal plea. Okay. The one they whisked him away on during the Bobo investigation. Well, isn't that fun? Yeah. DB with the reaction for me. Weinman wasn't upset about it. He didn't withdraw till he had to because Spiro realized he'd represented Britt. Oh. Isn't that like, it's like every time we hear there's an issue with a conflict of interest, right? We have this whole Luke Evans thing and like whatever that might be. But nobody sat here and screamed to a court about somebody when it was Weinman. Like, I don't know. I guess part of that would be Jason Autry wasn't the one that made it to trial and tried to point to Britt as a third-party culprit. But still. Like, just why? And it's like, why would Weinman think that that was cool? Like, it seems inconvenient. Maybe raise the issue out of an abundance of caution and let the court determine. But more importantly, like, the state never seems to have an issue when a potential conflict would be beneficial to them. Yeah. Trial and Error Podcast says, isn't that a conflict of interest? How does that even happen? And then Weinman immediately withdraws. Like, I don't get why you wouldn't just ask the court in the first place, period. Like, everything that I watch, it seems normal for, hey, we don't think it is, but we just wanted to bring it to the court's attention. DB says, why did Eric withdraw for Autry's appeal? Doug seems to hint at it in court that the United States Attorney's Office wouldn't let Beth talk about that. And then trial and error says she's the one whose house he was at when he got arrested for the gun charge after getting out on Holly, who recently died, very suspicious circumstances. Like, what? Is there anything about the timeline of this case that doesn't raise an eyebrow now? And then Zach puts Spiro in contact with Skylar Pinkley, who put Spiro in contact with Jason Autry when they were hiding him in the prison system and no one could find him. Oh, did they put him under like a different PIN number? Well, I guess that's redundant. A different PIN. This is a lot. So I think you're saying here that Skylar Pinkley is the person whose house he was at when he got arrested. Like, this is a lot. Hey, Christy. Saying hey to you when you catch up. Good to see you. Hope you're doing well. This is a lot. Yeah, like, Adventurin says people ask stuff like that all the time. It seems so normal. It's like, it's almost like small talk, layperson talk, like, how are you doing today? I'm good. How are you? Like, oh my goodness. But yeah, and there's even hotlines for attorneys to call and ask that type of thing about a conflict of interest and rules of conduct. Like, oh my goodness. There is a lot. There is a lot. It never seems to make more sense the further we go along. I mean, I think Doug is doing a great job of making it make sense of what doesn't make sense. The what is going on. The what is going on. My favorite header of all time. All right, so we've got, where were we? I think we were a motion to quash the subpoena was the last thing we were. No, state's motion to clarify record. And then we're still on March 7th, guys. We're still on March 7th. The document dump on the docket. So state's response in opposition to Katie Spiro's motion to quash the subpoena. Oh my God, this is a long one. Guys, we're going to do some skimming. This is linked in the description if you want to go and read it. It's one of the final March 7th filings. And again, it's called State's Response in Opposition to Katie Spiro's motion to quash. So the state's going to show that Dr. Katie Spiro is a licensed neuropsychologist who has actively participated in Petitioner Adams' post-conviction case, and Dr. Katie Spiro represented herself to this court, to the Tennessee Department of Corrections, and the federal holding facility in Memphis, Tennessee, as a neuropsychologist, not a member of the media. Petitioner Adams' post-conviction pleadings are replete with references to Dr. Katie Spiro's work and involvement in this post-conviction matter. On January 22nd, 2024, Petitioner Adams filed a sworn affidavit of Katie Spiro, including her curriculum vitae, with this court that laid out a detailed description of Dr. Katie Spiro's professional credentials, summations of her interviews with numerous witnesses involved in this matter, and conclusions based on her investigation. Upon information and belief, Dr. Spiro video recorded her interview with Petitioner Adams on December 1st, 2023, in the Tennessee Department of Corrections. Upon information and belief, partial footage of this interview was broadcast by ABC News 2020 on May 31st, 2024. On December 15th, 2023, Attorney Bates' office emailed the visitation office for the federal holding facility in Memphis, Tennessee. Neuropsychologist visitation was the subject of the email, and the following information was provided. Okay, awkward shape. December 1st, 2023. This is the interview. Spiro goes and does this video recording. We have no paragraph before this that says, hey, Doug Bates emailed to set up this December 1st meeting. We just jump right to Dr. Katie Spiro goes and does this video interview with Petitioner Adams. December 1st, 2023. They say this is broadcast in May. This is the same thing that's broadcast from December 1st. It's broadcast later in May of 2024. Then we have enter Attorney Bates. Attorney Bates enters December 15th, 2023. Emails the visitation office for the federal holding facility saying neuropsychologist visitation. Are we going to make a leap between these two things? Dr. Katie Spiro / forensic and clinical neuropsychologist, and date of birth, which was omitted for the purpose of this filing. Her business name is Fax, great name, just like Trial and Error Podcast is a great name. Inmate Jason Autry, visitation request December 22nd, 2023, from 10 to 1. They omit the driver's license here, but it was submitted in the actual correspondence. Dr. Spiro would need to be in a non-recorded interview room, attorney visitation room, and would request to bring her laptop and an electronic device for transcribing purposes. They say, see attached Exhibit A for 12/15/2023 email. So, yes, importantly, so this is the state's argument. They are arguing that this December 15th email made the representation to the Federal Inmate Visitation Center that it would be a neuropsychologist visitation. That was the email on the 15th, and not about that December 1st meeting. Hey, Dolly. Good to see you, Dolly. Hope you're doing well. I'm doing well. Anyway, on December 18th, 2023, Attorney Bates' office sent a follow-up email to the Federal Inmate Visitation Center advising that Dr. Katie Spiro would like to bring her assistant for the neuropsychologist visitation. I think this is Nicole. On December 22nd, 2023. And we'll look at these emails when we get there. We'll look at these emails later. Dr. Katie Spiro met with inmate Jason Autry for his neuropsychologist visitation on December 22nd, 2023. Oh, is this maybe if using this pen I can hold shit? No, that does not let me draw straight. Let's try again. Nope, not very good at this. At the Shelby County Division of Corrections Visitation Office, Dr. Katie Spiro, working on behalf of petitioner and petitioner's attorney, video recorded a conversation in federal prison with inmate Autry about his testimony during petitioner's trial that was provided by Spiro to ABC News 2020. All right, so maybe this is a separate provision, but I still don't get why they're taking issue with this December 1st, where it wasn't Doug Bates that set it up. On April 1st, 2024, Dr. Katie Spiro, in an email attempting to schedule a Zoom meeting. Hey, FFS. Good to see you. Good morning. Represented to the Department of Corrections that she was Dr. Katie Spiro, with her signature stating she was Katie Osborne Spiro, PsyD, and that she was a forensic and clinical neuropsychologist. So they say, go look at that exhibit for the April 1st email. At no time in this email did Dr. Katie Spiro represent to the Department of Corrections that she was meeting with Petitioner Adams for media purposes or as a media source. And they say, see Exhibit D for the media policy. On April 5th, 2024, Dr. Katie Spiro emailed former Assistant District Attorney Jennifer Nichols with the subject of introduction, and with her signature stating she was Katie Osborne Spiro, PsyD, and that she was a forensic and clinical neuropsychologist. See Exhibit E for email with former ADA Jennifer Nichols. On April 8th, 2024, Dr. Katie Spiro attempted to schedule another meeting with inmate Autry at the federal holding facility in Memphis, Tennessee. She did this via an email on which Attorney McClendon was copied. If this was really like, if she's lying, if she's breaking rules, if she's doing something that she's not supposed to, there are other pathways of action here. Has there been any other punishment? Has there been any punishment for Dr. Katie Spiro? Did anyone successfully, file for some type of injunction? Did anyone get her license taken away? I love Jennifer Nichols would love to imagine that that would be the end outcome, but did anybody entertain that? It seems like the bigger play is the state is excited because they can't attack Doug Bates' petition on the merits of the argument, on the substantive issues of the 2017 trial and conviction of Zachary Adams. So this seems like they think they have a chance to run out on the field waving a flag that, oh my God, Doug Bates is doing something shady. The petitioner is shady. That's what this entire saga seems like. And also crying a little bit because there's some media attention. We can't control the media narrative anymore. And the media narrative might not be 99.999% in the state's favor if we have people like Katie and Dana doing a podcast. So I think they're just really excited to be like, oh my God, they're lying. The petitioner, they play dirty. So don't just look at us and we play dirty. Because otherwise, if you really thought all of this was wrong, why wouldn't you take other action about it? And even if you do take other action, asking for some type of punishment, did another disciplinary body agree with you? So they say here, she's talking about whether she inquired whether the prison had a notary on site or if she should bring one. And again, I think it's really critical that the facility was like, oh, we have notaries. So there's nothing weird about her wanting to bring a notary or asking if a notary was available. It's practice. They have someone there for that function because it's a normal thing. They say it's the state's belief that Ms. Spiro intended to obtain an affidavit from inmate Autry, casting doubt on his trial testimony. What's wrong with somebody obtaining an affidavit? The only thing wrong with it is it would put the state in hot water for the purposes of these post-conviction relief hearings. Because I'm pretty sure an affidavit would have gotten, if the affidavit wasn't redundant to that recanting video, it would help the court decide, hey, you know what, we actually can consider the recantation as part of the record. Prison officials declined her request to meet with inmate Autry. Neither inmate Autry's attorney of record nor petitioner's attorney were copied on her email. Notably, in these email exchanges, Dr. Katie Spiro held herself out to the facility to be Katie Osborne Spiro. But that could just be how someone signs all of their correspondence if they have a signature in Google and they just can't put a canned template for their signature at the bottom of certain correspondence. Okay. And that she was a forensic and clinical neuropsychologist. At no point during did this email exchange, you know what? Amy Wyrick would love to have email correspondence with realtors. Working with real estate agents, do you know what real estate agents love to do? They love to tack on titles and certifications. There are some realtors out there that their title in their email signature will have 40 different acronyms for different certifications that they have. That would probably drive Amy Wyrick nuts. Let me get rid of my ripples. At no point during this email exchange did Katie Spiro indicate to the federal facility that she was attempting to meet with inmate Autry for media purposes. Now, I do understand, right? They want to get around the argument made in the motion to quash that, hey, she should be protected under the grounds that she was doing this for media purposes. Fine. I think they can argue that. But I think everything else is just a dirty play to point the finger and say, haha, look at them. They're shady, even though they're emailing us saying, hey, we'd actually love if you want to talk to us. We're not trying to hide anything. On May 31st, 2024, ABC News 2020 aired an episode covering the Zach Adams case. Dr. Katie Spiro appeared in the episode and identified herself as a forensic neuropsychologist that was hired by Attorney Bates to review the case and assess the truthfulness of witnesses. I mean, both can be true. Two things can be true. That can be an and. Dr. Katie Spiro was also indicated in this 2020 broadcast that she works directly for the petitioner's mother, Cindy Adams, not Attorney Bates. Yeah, and maybe that's how she was employed at the time. And the state knew this because they subpoenaed Cindy. And that's probably why they subpoenaed Cindy. So would it not be possible that, hey, at some point she's doing work in 2023 while working for Cindy Adams. And then at a different point in time and for different purposes, perhaps overlapping, Attorney Bates brings her on. Two things can be true. At no time prior to the filing of Dr. Katie Spirko's motion to quash has she represented to this court that she is a member of the media. Upon information and belief, Dr. Katie Spirko has never filed a request with this court under Tennessee Rules of Superior Court 30 for media access. Petitioner Adams has relied upon by Dr. Katie Spirko's work, opinions, and conclusions through his pleadings with this court. Dr. Katie Spirko cannot now claim that she is a member of the news media and invoke the privileges afforded to the news media under 24-1-208. All right, so furthermore, Dr. Katie Spirko's motion to quash contains broad conclusory statements, and look how long these arguments are. Their motion to dismiss didn't flesh this out. Their motion to dismiss was 9 pages and some references to other filings. But here they're actually spelling out the specifics again. I think it's so telling to look at when the state wants to put things on the record in a motion that any member of the public can, well, there's a little bit of obstacles here to pulling this and reading this now. But at some point, they had a whole media page so the public could go and read these documents. It just got pulled down the other day. When they want to tell something, they're going to detail it. When they don't want something being told, they're going to just be like, reference this paragraph. We disagree. So good times, chat, good times. But yeah, so absolutely no details have been set forth explaining how she's a person engaged in gathering information for publication or broadcast. 2, employed by the news media or press. Or 3, independently engaged in gathering information for publication or broadcast. I mean, what if Cindy Adams hired her hey, the media spin on my son is horrible. They're saying horrible things about him. There's other information out there, and I need help getting the public to see that side of things. I don't know. We had a little bit of acknowledgement here about Cindy Adams, but we don't have any dive into the relationship between Katie Spirko and Cindy Adams. It could have been exactly what the state's saying isn't there. Dr. Katie Spirko's assertions in her motion to quash that she's a member of the news media directly contradicts her numerous representations to this court, Tennessee Department of Corrections, and the federal holding facility that she's acting in the role of a licensed neuropsychologist. And I think the court, well, explain yourself. All right. But then that would get Katie a chance to speak in court. So I don't know if the state would really benefit from that in the end. Alternatively, in the event this court determines that Dr. Katie Spirko did qualify under media privilege, the state would submit that Dr. Katie Spirko should be divested of same privilege. The state would show at a hearing that A, there is probable cause to believe that Dr. Katie Spirko's information, which is clearly relevant to a specific probable violation of law. B, the state will demonstrate that the information sought cannot reasonably be obtained by alternative means. And C, the state will demonstrate a compelling and overriding public interest of the people of the state of Tennessee in the information. What? Shouldn't they argue the opposite? Anyway, maybe I'm missing their argument. Maybe they forgot to add the contrasting word. But I feel like they should argue the opposite. Unless by the people of the state of Tennessee, they mean the state in the prosecutorial capacity? Or is this just public access to information here? Anyway, whatever. Dr. Katie Spirko is not a private detective or investigator, as contemplated by 24-1-209. Alternatively, any such privilege was waived by Petitioner Adams by Dr. Katie Spirko filing her sworn affidavit and or releasing recordings of her work to the media, and or by allowing Dr. Spirko to disseminate video recordings to the media. I don't think that that's how this works, but I'm not a lawyer. I don't think just because somebody files an affidavit Like, does that mean anytime an attorney files... Tyrone Blackburn would never have attorney-client privilege. Anyway. So 24-1-209 states that communications between an attorney and a private detective or investigator hired by such attorney while acting in their respective capacities shall be privileged communications. Again, Dr. Katie Spiro has represented herself to the court as a licensed neuropsychologist, and she has offered her professional opinion in this post-conviction matter concerning witnesses and evidence. Petitioner Adams' post-conviction pleadings are replete with references to the work and opinions of Dr. Katie Spiro, and Dr. Katie Spiro's sworn affidavit contains numerous mentions of her work and opinions. I really only... And, like, the documents are getting lost, right? Because there's a lot of them that we've been reading in the last week. But I really only remember Dr. Spiro... Yeah, she had her own affidavit. But a lot of what was raised as an issue in the petition, it's not cited back to Katie Spiro. But here it's like they're overemphasizing that if we remove Katie Spiro from the picture and remove any work that, like a fruit of the poisonous tree argument, then a petitioner would have nothing because she's referenced everywhere. And I would not characterize the petition as relying heavily or making all of these references like to Katie Spiro that if we pruned her out of it, it would be like a page long. Yes, GV. GV wants us all to know that Jennifer Nichols comments on her judge Facebook page posts, "Amen," using her personal account. She responds to herself. Oh man, good times. Alternatively, if any such privilege existed, Petitioner Adams waived this privilege by sharing with the state the affidavit from Dr. Katie Spiro containing and by citing Dr. Katie Spiro work in his claims for post-conviction relief. Petitioner Adams cannot now raise a claim of investigative privilege when Petitioner Adams voluntarily provided the state with Dr. Katie Spiro's affidavit and incorporated the facts set forth in same affidavit into his pleadings. Yeah, and that's how I would look at it. Like, isn't it typically in a limited capacity or like a relevant capacity? And it wouldn't be like if Katie released, if something that Katie did on December 1st, which the state has not provided any tie to Doug Bates saying like, hey, do this as an agent of Zachary Adams. If she's doing something at that point, like, and she releases that information, then that wouldn't be something there wouldn't be attorney-client privilege for Zachary Adams, right? That wouldn't even be like a claim for Zach Adams. But it would also mean that something that she did on outside the capacity of Zach Adams, because the state just seems to be lumping everything together. Like anywhere Katie Spiro has lived, they want it to all be assumed to be under the directive of Doug Bates, working in an agency capacity under Doug Bates for the petitioner. And like they're ignoring that somebody else also hired her. Like, I don't know. To me, it just seems like a little bit of flailing. And I don't get, this is all just to address the issue of journalistic, like a media role. So, furthermore, the state would submit that Petitioner Adams waived this privilege by allowing Dr. Katie Spiro to record video interviews of Petitioner Adams and then disseminated the same to media. But, for me, when you record something with somebody, then doesn't that just remove privilege for that transaction? Yes, FFS, she does actually do that. Like, oh my goodness. Just crazy. It's a good time. I think GV also made a button because I think the campaign is something like keep Jennifer Nichols as judge, and she changed the bottom text to read keep Judge Jennifer Nichols away from me. Oh my goodness. Yeah, so Trial and Error Podcast says the privilege belongs to the client, not the state. Zach is perfectly able to waive privilege and consent to Spiro releasing the footage. The state has no right to insist on it being kept secret. And they're arguing it both ways, which is what I don't get. They're arguing it both ways. And then in doing so, they're also making the argument that, you know, it's just so, there's like so many conflicting layers, because if they're saying that this isn't evidence or whatever, they want it out of the record entirely, then there wouldn't be an argument of like, hey, one party is taking evidence from a pending matter and disseminating it to the media, which hurts arguments they've made elsewhere. Yeah, this is driving me nuts too. They argued against the initial petitions, like, you don't even have Jason Autry signing an affidavit. These aren't sworn statements. It's just a video recording, and there's no indicia of truth. Okay, so then you have a complaint when someone's trying to get an affidavit, which is apparently a normal procedure if they staff a notary. Like, it just doesn't make sense. This whole thing should just be a short argument about, look, we don't think that this rule that Turin is arguing, this motion to quash, we don't think relying on this media, the statute that applies to media applies here. Here's why. But this is like a flailing, like, God, Katie Spiro. Like, oh my goodness. Just crazy. I just get annoyed when it like doesn't make sense and it's argued both ways. Partly, and it's sometimes that's just it's annoying. I think it's them trying to hide, you know, they don't want the truth to come out. But secondly, in a selfish way, I really like to learn. Like, I'm not a lawyer, so when I read arguments, when I read someone making an argument in a filing, it's hard for me not to give weight to the argument that they're making, because they're the lawyer, they're the attorney. And so when I'm reading things that are like, well, that's contradictory, that doesn't really seem to support to say that, it's like I feel a tug of war inside myself. Like, am I just not understanding it? Am I just not trusting what they're saying? Because overall, I have a trust issue with the attorney writing this filing. But are they right? And I'm just covering my eyes to it. But it really hurts the learning process. Like reading these motions where, hey, this says you can't do that. It clouds the learning process. Gotta love it. Also, shout out here with the party hat, celebrating the birthdays early. And I think you're in a bush. Are you in a party bush? Oh my gosh, guys, I think Sheriff Chuck is in a party bush. That is hilarious. So we have 5 gifted memberships. He said, come on, come join Kathy Ferguson in the bushes. Come join Marissa Viverito in the bushes. We are having a party. We have some guy with cancer's birthday tomorrow. We have Adventure and Aaron's birthday on Sunday. Come fill out the party bush. Oh, it's green ducks? Okay, it looks like, you know those bushes that have like those little bright red berries that, I think they're gooseberries? There's like one that's edible and one that's really poisonous. But they look really similar. From my vision, which is probably not the best vision, it looks like one of those bushes with the little red berries. But it's apparently green ducks, which is also awesome. Oh, goodness. Thank you for gifting 5 memberships here. And love the new picture, even if I looked at it wrong. Art is in the eye of the beholder, right? So we've got, yes, party bush is crazy. Well, I think I forced that interpretation here on the picture. So here they are. They want to deny this motion to quash, give us any relief we're entitled to, and then do we have the same? Okay, this is March 7th. Okay, yeah, this looks like the one from Doug, but it's being forwarded. So they're forwarding this to Jamie Littlefield on March 7th, 2025. All right, same thing. Another forwarded. This is the April 1st email. Can we waive? Is this Jennifer Nichols' notes? Can we say she waived her privilege because her work product, her notes are on this filing? Because that's the logic she wants to use. Or Amy Wyrick. Did I say Jennifer Nichols? I meant Amy Wyrick. All right. And then is she okay? This is attaching the rule. So effective November 15th, 2019. Yeah, so they're just attaching the rule here. So all Tennessee Department of Correction employees, offenders, and privately managed institutions are who this applies to. This is to establish guidelines for provision of information to the public and regulate staff and offender contacts with the media. We've got, they're going to define all the roles. News media is defined as Tennessee-based news publications, accredited news services such as the Associated Press, licensed radio and television broadcast stations or networks, government franchise, newspapers, magazines, publish at least weekly or monthly and containing news and feature articles appealing to a broad spectrum of interest. News media excludes broadcast programs syndicated by independent producers or television stations or networks for the primary purpose of entertainment, and syndicated television broadcast talk shows. And then let's see. Policy. The TDOC shall manage contacts with the public and media, including internet website content and social media sites, through the communications director to ensure accurate dissemination of information and appropriate access to the institutions and offices without disruption to security or operational routines. All right, where's the relevant portion? I guess what I don't understand is the emails weren't saying like, hey, I'm a news media organization. So why did they grant the prior meetings? Because I don't really think they granted the initial meetings under these reasons either. I feel like this is something I'm not going to figure out because it's just not going to make sense. So April 5th, 2024, we have the FYI from Jennifer Nichols de Boyano, where she's relaying to him that, hey, Katie Spiro says, hi, this is who I am. I'm not speaking for Dana McClendon. I'm just speaking for myself, and he's CC'd here in case you want to contact me. Please don't hesitate to reach out to me. The notary on, it's the same emails. So I'll just say I'm still lost. I'll just say I'm still lost. Oh, that would be interesting. Like, and then was it like, hey, this is for a media interview, or, and I still don't get, how are any of the emails that they've included as exhibits supposed to show that Dana McClendon was incorrect in his 2 lines of his declaration. Like, whatever. Whatever. So that was that. The next thing, you guys, was unavailable. It was titled as Exhibit A to Jason Autry motion, and it wasn't available for download. So I would assume maybe it went under seal. And then we're moving on to March 11th. So March 11th, we have 2 filings. All right, and they want a motion to quash. This is for former counsel for petitioner Jerry Gonzalez and Jennifer Thompson. Jointly moved to quash subpoenas issued on them for their entire records and computer systems is overbroad and outside the limitations. Jerry Gonzalez, and again, he's correcting his name because the state's been spelling it with an S this whole time. They have been subpoenaed for production of documentary evidence on behalf of Respondent State of Tennessee by Amy Wyrick, Special Counsel, 25th Judicial District. They have a footnote that says the subpoena typeface is so small as to be barely legible. The signature of the issuing party's attorney is completely illegible. The subpoena includes references to a list of items to produce that must be produced at Bates & Bates Law Office in Centerville, Tennessee, before March 7th, 2024 at 1:30 p.m. The subpoena also states that a failure to serve an objection to the subpoena within 21 days of the day of service of the subpoena waives all objection. And there was a footnote. It says complying with this deadline is impossible. March 7th, 2024 has already passed, so they had the year wrong. The attached list of items to produce includes complete case file, and like half of this is in quotations, guys. It's like there's like 1 word of not quoted words here. All statements and memos related to witnesses, all that stuff. They wanted everything. It was overbroad. They say this list is grossly overbroad. First, an order of this court dated February 21st, 2025, and filed in the record on March 3rd, 2025, ruled that the state's motion to deem attorney-client privilege waived is granted in part, and we read this with the court saying, when you prepare your order, you've got to make sure that you're being aware and you're not being so overbroad to forget about attorney-client privilege. It is granted in part. The list of items to produce is far more broad than this court's order and is not limited to the boundaries set by the court. This court's order limits disclosure to only those records dealing with attorney-client privilege. It says nothing about work product of attorneys, which enjoys a separate and distinct protection from production. Rule 17d2 provides that a subpoenaed person may move the court to quash or modify the subpoena if compliance would be unreasonable or oppressive. The subpoena demands these counsel to produce at the offices of Bates & Bates their entire computer system. And also this is located in the Bates building. That is, all computers, including backups and all storage devices in their possession related to any legal work performed in the Adams case. This would encompass the entire computer system, without limitation, including computers and hard drives that contain hundreds and hundreds of files related to other cases in other courts. Such would effectively shut down these counsel's entire practice for the duration of their computer's absence, require them to spend thousands of dollars to purchase a duplicate computer system, spends many hours attempting to scrub the produced computers of other case files, or expose to the state of Tennessee and to Bates & Bates the protected work product and privilege files of hundreds of other clients. This is simply unprecedented and an outrageous demand and totally unreasonable. These counsels simply cannot comply with such a demand and would be required to appeal to as high authority as possible to limit such a universal disclosure of protected information. Additionally, the undersigned backs up his files to a cloud service. How is he supposed to produce those hard drives, likely contained in massive server facilities in the East Coast of the United States and/or Canada? Now, this just seems like you're pissing me off so much that I'm just going to make you sound dumb. Rule 17d also provides that the court may condition denial of the motion on the advancement by the party on whose behalf the statement is issued for the reasonable cost of producing the books, papers, documents, or other objects. A very conservative estimate of such costs would be in the range of $10,000 to $15,000 for each subpoenaed counsel herein to cover a new computer system, monitors, time to scrub the computers or other client files, and cost to hire technical support to set up the new computer with duplicate software. For these reasons, the subpoena issued should be quashed. If this motion is denied, then these counsel move for a temporary stay or extension of time to comply so that they may appeal to a higher authority. So Jerry Gonzalez powered this one out and was joined by, and he signs as Jerry down here. And this was enjoined. This is a copy of the subpoena. But remember at the beginning they said that Thompson was joining in on this. All right, so next up we have all right, so under penalty prescribed by law, you are commanded to summon Cindy Adams. So subpoena here for Cindy Adams. This was issued on March 11th. This is Zach Adams' mom. All right, and that's all it is. It's just a copy. So guess we want to talk to Cindy. Wonder if it's in relation to Katie Spiro. Yeah, so Sheriff Chuck, for what we were looking at earlier, the Tennessee Department of Corrections policy, that's a policy, and I wonder how it would hold up against the First Amendment. Yep, Adventure Aaron, I agree too. I mean, reading that policy is what made the light bulb go off. Like, well, they granted her permission for whatever she was doing at first. And not for nothing, but even if someone represents themselves as media, does that stop? Is that where the responsibility for vetting for the Department of Corrections would end? You don't ask to see any press credentials. So, I mean, to me, this whole storyline that, like, Katie Spiro is somehow representing herself to be a neuropsychologist, so she shouldn't benefit from the motion to quash under the media guidelines. Okay, maybe isolate that argument. But how can you then, the same person in the same filing, start complaining about how the Department of Corrections did grant her access to meet with an inmate or two inmates at different periods in time previously, when you're admitting that she was a neuropsychologist and she's signing off in her signature as being Dr. Katie Spiro? So that would seem to me to be pretty clear that she's not even trying to mislead the Department of Corrections by saying, hi, I work for a media agency and I'm looking to get information by doing an interview with an inmate. So, I don't know. It just seems like they are trying to kick and scream. All right, then there was an order continuing the hearing. So on March 12th, the court previously set a hearing for March 18th, but based on conflicts with different attorneys involved in the matter, court finds it appropriate to continue this hearing for March 21st. Next, we have petitioner's response to motion to appoint Jason Autry an attorney. So this is Zach Adams saying, hey, the state has filed a motion with over 700 pages of attached exhibits, which we did not get to see. It is a far cry from the state's, quote, emergency to attempt to seal the video of Mr. Autry recanting that petitioner attached to its writ of error coram nobis. Yeah. The petitioner asked the court to view this motion in the larger picture of the state's efforts in this case and on the motion set for hearing on March 21st, 2025. To summarize, the state is concerned about the need to appoint an attorney for Mr. Autry for him to testify, while accusing him of using drugs in prison in December of 2023 and repeatedly stating that Mr. Autry is not going to admit he perjured himself in 2017. The state can cite no authority for the proposition that the court can appoint an attorney for a witness without even the witness requesting such. The state feels it can regulate who an agent of the defendant Dr. Katie Spiro can retain to quash a subpoena. So we've got a footnote here. The state seems to complain, and we got a long footnote. The state seems to complain most about the podcast of Dr. Spiro. See, all of my ranting and confusion and my inability to rant. When I'm confused, I can't formulate a rant. Look at this. I'm satisfied here. So we've got Doug and Crystal saying, the state seems to complain most about the podcast of Dr. Spiro, while it is seemingly quiet on the publicity that the very able and popular local journalist Burton Staggs posts about this case. And at some point, did he get added to some type of possible witness list? Oh, I didn't mean to cross them out. I meant to highlight Burton Staggs. Because I thought I heard that at some point he might have been added to a witness list, or like the state was looking to speak with him. But maybe I'm just making that up. I'm hallucinating that. But this kind of makes it make sense. Like, it's only Katie Spiro. Why? Why? Well, maybe we don't like the way that Dr. Katie Spiro's podcast that she has with Dana McClendon is making people ask questions about the case and the individuals who played a key role in prosecuting it. So they're seemingly quiet about Burton Staggs, who posts about this case while stating he is close to the Bobo family, which is absolutely his right. So shout out to Doug and Crystal here for not trying to, like, we're not making this about Staggs, we're making it about the hypocritical standard. Mr. Staggs is obviously an independent investigative journalist who has had his own videos and news appearances in this case, pre, during, and post-conviction. He recently posted many of the exhibits the state provided in support of their motions on his Facebook page. Because this is a bench trial, petitioner's counsel is not concerned at all with any pre-hearing publicity affecting this court's decision. That's important too. As it is anticipated, the court will pay zero attention to any of it. So what is this suggesting in the alternative? Hey, we're sharp enough to realize, hey, this isn't going to impact the recourse of what we're here for. Because, Judge, you should not be looking at this stuff. On the flip side, why would the state be panicking so much? Why would the state be panicking so much? Because the public is questioning the players that helped craft a conviction. And not for nothing, but I listen to podcasts all the time that point out who did it. I'm really not a fan of like the true crime genre of podcasting, personally. Because sometimes it stays so far in the realm of speculation and theory and emotion that you can, by the time you're done listening to an episode about something, you have to question, like, hey, am I thinking somebody did this thing because it's a really sad story, or did they actually cover evidence in this podcast episode, or this TV series, this episode on TV? Is it my heartstrings, or is it the logic that's getting me to the way that I feel? And I think a lot of the true crime genre, it's sometimes almost entirely emotionally compelling and not very compelling through the evidence. So I can see why the state would be worried about a podcast that comes out and says, hey, actually, seems like you wrongfully convicted somebody and failed to prosecute, or at least look at somebody else that may still out there being a dangerous person in society. So, and don't get me wrong, I love like entertaining conspiracy theories. I like to think about things. I like to just ponder for the sake of pondering. But I think the Trial and Error podcast, they're really laying out and organizing details. And maybe they're asking questions. But I don't think they're just saying, you know, you read a headline in the newspaper and it's like, such and such event happens. Here's why that matters. And then they argue to you throughout the article what you're supposed to think about the thing. And that's not the impression I get from the Trial and Error podcast. So, where were we? We were at this footnote. And then the state has still failed to simply provide the defendant the ATM video. What is going on? The elephant in the room. The screenshot of Mr. Adams' General Boyano reference in court in January and the investigative subpoena for the reference ATM video. That's exactly why I think we have 39 pages or whatever it was of the state trying to freak out about Katie Spiro. Don't drink every time I say Katie Spiro in this episode. The sole reason we are having Mr. Autry even appear on Zoom is because the state refused to request the court to transport Mr. Autry from his federal facility. This is hard to reconcile with the enormous efforts that went into securing Mr. Autry's pretrial work with TBI. The petitioner does thank the state for its filing of Joe Walker's federal testimony that not only confirms this, but also reveals Brady material that was not disclosed in that Mr. Autry was not emotional at all when telling Agent Walker the events of April 13th, 2011. Mr. Autry's flat affect was in stark contrast to recorded interviews by federal agents with Mr. Autry about gun charges pre-indictment in this case, in which Mr. Autry cried openly about the situation he was in. In other words, when the state needed Mr. Autry's testimony, they took him from Nashville to Memphis to Decatur County and then to Hardin County to testify. When they do not need him, he is, quote, too dangerous. Tell them, Doug. A question the court might want to pose to the state was he too dangerous to be the icing on the cake, in Agent Walker's words? In the prosecution of Mr. Adams, I might have to go rewatch that little snippet of Joe Walker. Oh, man. To recap, deny signing the 10-point letter for Autry's physical attendance, request the appointment of an attorney for him without his knowledge. At one hearing, the state requested Mr. Scholl be reappointed, requested an attorney, petitioner's counsel, not meet with this witness before the hearing, all to make it as difficult as possible for the court to examine Mr. Autry. Now, this makes, can you imagine imagine the role reversal? Imagine it was like Amy Weirich was imagine Amy Weirich was in Doug's shoes. And she was faced with having to tell the court, look, we think that Doug Bates and his attorney, his client, he was working with his client to fabricate a story, to suborn perjury. Court, this is a serious issue. Judge, this is a serious issue. And now this is like years down the lane. Doug Bates isn't currently representing the client. And Doug Bates comes back on. You would never, Amy Weirich would lose her mind. Because it's a huge conflict. Mr. Scholl, if we accept what's being claimed by really not just the petitioner, but Jason Autry in that recanting video, that we put the story together. Who's we? Scholl brings him the evidence folder. Scholl has an interest in, no, the testimony he told at trial was true. He's got a vested interest in future proceedings maintaining as such. So for the state to suggest just put Mr. Scholl back on, horrible. They think it'd be a conflict of interest to have Attorney Eric now expand her role in her representation to include this matter. But it'd be fine to bring Mr. Scholl back on, in spite of what's being alleged in the petition for post-conviction relief. It's just crazy. It's just crazy. And, I think it's great that this is being laid out in this. So, yeah. So, and then also they go on to request that an attorney, petitioner's counsel, not meet with this witness before the hearing, all to make it as difficult as possible for the court to examine Mr. Autry. Perhaps the words of Justice Sutherland should be cited in Berger v. United States. So going back to 1935, that said a prosecutor's role in a criminal prosecution is not that it shall win a case, but that justice shall be done. Well, I always love a reminder. This is when counsel is losing their mind, that they really even have to argue this stuff. Let's remind them that you are not here to win a case. The petitioner submits that justice in this case is for Mr. Autry to appear, and if he so chooses to waive his Fifth Amendment right, testify and face the full brunt of state's anticipated passionate and forceful cross-examination against him, and then this court can render an opinion. Respectfully, Doug Bates. Douglas Thomas Bates IV. And Crystal M. E2. Love it. Love it. Some great motions coming from Doug's team here. All right, so next up, we are moving to March 21st. And this is going to be state's response to petitioner's motion to compel. So, and we're going to finish up, and we're going to try to finish March, unless one of these is really long. Then we'll have to call an audible. They could get long, but I'm going to try to finish these up for this stream, and then we'd have all of this left still for tomorrow. All right, so State of Tennessee, by and through the undersigned attorneys, files this motion. Response to petitioner's motion to compel the state to comply with Rule 28. The state would like to show as following that this court's order on January 16th, 2025, the hearing where we see the truck on the tablet screen, Boyano screen, which was entered on February 3rd, renders this issue moot by ordering that the remainder of the state's motion to dismiss issues be held under advisement until after the evidentiary hearing. So they want you to deny this because of that. All right, motion to compel photos. So this is about the ATM stuff. So this one's long. Of course this one's long. Of course this one's long. Oh, Aaron, the Brittany Drexel case was just insane all around. Another situation where they have a couple working together to prey on and abduct a girl, and the law enforcement was pointed right to them in the beginning, and they were told nope, they were good, had to be somebody else, falsely accused somebody else later, who they also say, hey, you've got a different plea, like a prosecution pending for armed robbery, severe sentence. Why don't we'll work out a deal with you if you take the blame in part for this Brittany Drexel case. Had this guy plea to say that, like, his friends, his homeboys at, like, I think it was like some drug house event, that he knew that she was there and that they ended up killing her that night. And he failed a polygraph test and everything, which I know that's not admissible, but still had him take this plea in that case. And they do this big media thing about it. Oh, we solved the Brittany Drexel case. Well, not so. They end up finding out it was really the initial couple that law enforcement had their eyes on and was told to look at right away. Just crazy. Just crazy. The Brittany Drexel case pisses me off for a lot of reasons. Ugh. But it makes me think about, like, the Brits in this case. So they've got, let's see, Petitioner Adams' assertions to this court that neither his trial counsel nor post-conviction counsel have had possession of the ATM video at issue are categorically false and absurd. On or about June 19th, 2015, Jennifer Thompson signed a receipt of discovery acknowledgement. That doesn't really mean that you've looked through everything in detail. That's like when you get the line item list. We looked at one of them. It was like a 3 line item list earlier that we looked at. You sign off. All right. You don't go through the files before you sign off. That confirmed the physical delivery of an external hard drive to Petitioner Adams' trial counsel. See attached Exhibit A for June 15th, 2015, Rule 16 discovery letter. Once Attorney Bates was appointed by this court as Petitioner Adams' post-conviction counsel, Jennifer Thompson offered to surrender her file to counsel Attorney Bates, which counsel Attorney Bates accepted. From January 7th through 9th, 2025, undersigned counsel traveled to Attorney Bates' office in Centerville, Tennessee, to review and copy all of Jennifer Thompson's case file materials. Among Jennifer Thompson's case file materials included an external hard drive, which the Tennessee Bureau of Investigation digitally copied and then returned to Attorney Bates. On the main root directory of Jennifer Thompson's external hard drive folder is a folder named, it says ~1 Jackson TBI. See attached Exhibit B for Step 1. Contained within the Jackson TBI folder is another folder named Investigative Report 1845. That's going to be all in Exhibit B. Contained within the IR folder is another folder named Video. Contained within the Video folder is another folder named V8. Contained within the V8 folder are 3 video files and 1 executable application named Install This First to View Video. Oh my god, how many steps? Like, isn't it problematic that we have to outline how many steps there are? So, if a user double clicks on the Install This First to View Video executable application, a DV video player installation will appear prompting directions on how to install the program. After DV player program installation is finished, a user will be able to launch DV player and view the ATM video at issue. The state is prepared to show this court that Jennifer Thompson had possession of an external hard drive containing the ATM video since approximately June 19, 2015, until such time that she surrendered Petitioner Adams' trial file to Attorney Bates. The state is prepared to show this court that Attorney Bates provided Jennifer Thompson's same external hard drive to the TBI in early January 2025 for copying and review by undersigned counsel. Furthermore, TBI issued an administrative subpoena under 38-6-102 and secured physical control of the ATM hard drive. Which was mirror image copied and provided to Attorney Bates on August 26, 2024. Yeah, only after Kathy had to run and grab it. Lastly, the state has not objected to Attorney Bates or Attorney A2's meeting with their client over Zoom. The state did have, and will continue to have, serious concerns about anyone other than Petitioner Adams' attorney of record to use the Department of Corrections Zoom conference technology to communicate with their client, especially those that deliberately circumvented established Department of Corrections rules and procedures. The state addressed those concerns directly with Petitioner Adams' counsel and this court, resulting in an order being drafted by Attorney Bates and Attorney A2 stating explicitly that Crystal E2 and Doug Bates IV shall have the privilege of meeting with Mr. Adams through Zoom technology. This privilege is not extended to anyone in these proceedings beyond Miss E2 and Mr. Bates, the attorney of records of Adams. And now let's go right to that exhibit. All right, so on February 26, 2025, the petitioner's attorney, Douglas Bates IV, filed a motion to allow him to meet with his client over Zoom. He filed a motion. He wanted relief for him to meet with his client. The relief sought was for Doug, petitioner counsel, to have this relief. The court finds that the motion is well taken to the extent that either or both Crystal E2 and or Douglas Bates IV may meet with Zachary Adams. It is therefore ordered and decreed and adjudged. So the court's like, hey, Doug asked for his own petition, but we're going to say you obviously mean your team. So it's hereby ordered that your counsel of record shall have the privilege of meeting with Mr. Adams through Zoom technology. This privilege is not extended to anyone in these proceedings beyond Miss E2 and Mr. Bates, the attorney of record for Adams. All further issues are reserved until further orders of the court. Now, this is not them saying, this is very different than saying the court has ruled that other people should not have access. Like, this is why I wanted to go down and read this right away. And this is the 28th day of February. We were on like page 3. Ooh, I could like leave a highlight when we scroll so I can find my place. All right, so they're saying that the state has not objected to Bates and whatever, but we have concerns, especially those that deliberately circumvent established Department of Correction rules and procedures. The state addressed that. I don't know, this is kind of passive language. They're saying that the state addressed it, To me, this is slick. The state addressed these concerns directly with Petitioner Adams' counsel in this court, resulting in an order being drafted by Bates and Etu, stating explicitly that Crystal Etu and Doug Bates shall have the privilege of meeting with Mr. Adams through Zoom technology. They're highlighting that the privilege is not extended to anyone in these proceedings beyond Miss Etu. But the issue is this order specifically notes that the other issues are unresolved and that this order doesn't resolve any of those other issues. But here, if you just read this, you would probably conclude this was all done to shut down and address all of these other people that are circumventing. So wherefore, premises considered, the state of Tennessee respectfully requests that this court deny petitioner's motion to compel production of photos and videos and motion to show good cause to release the investigative subpoena and affidavit. So I don't want to release any of the stuff. So transparent. So much transparency. Oh, goodness. And they had a bunch of stuff attached. So this is very wiggly. All right. So this is from Office of the District Attorney General. It's got Amy Wyrick's little letterhead thing. And it says, Dear Ms. This is June 15th, 2015. Dear Ms. Thompson, Mr. Herbison, and Mr. Maddox, please find attached here to one external hard drive and one disk. Contained therein is a discovery pursuant to Rule 16. This is where they're going to say that they signed off on this. There's an index contained on the disk. The IRs are numbered 1 through 2,986. The first IR refers to the initial complaint/investigation and is dated April 14th, 2011. Obviously, there's information included in your discovery that is not referenced in the aforementioned index. Please treat this material in a confidential manner pursuant to Judge McKinley's instruction at the last court setting and in the manner mandated by the rules of professional responsibility, rules of evidence, and rules of criminal procedure. All right, here's where you can find physical evidence. The bulk is going to be in Nashville at TBI headquarters. The physical evidence will be made available for your inspection. Nashville will be the first inspection site. Please coordinate. And we're aware of our ongoing duty to provide discovery. I copied Judge McKinley on this letter and thus will provide the court with a copy of this letter, the signed receipt of discovery from each of you, and a copy of the external hard disk and drive. So yeah, like signing off that you received something is not the same. Okay, but now they're going to go through the steps. So this is what you'd have to do to go access this one file. So step 1, open the Jackson TBI folder. Step 2, open the investigative report number 1845. Step 3, open the video folder. Oh, now we're sideways. Then open the V8 folder. Then double click to install an application. And I don't know, why is that like the only one that requires an installation of this application? But still, that seems stupid. Why can't it be accessible? Why does that one need an application? And then step 6, when the DV player application installation window appears, click the next button, install it, keep clicking next. Then you gotta look in V8. Then you've got to open the DV player application. When the video application is launched, an open window will appear. Then you got to go to the following directory on the external hard drive and then select the file and click the open button. So you got to open it from within the application. And then here's the still. I think this is what was on Boyano's computer. And they've got some other frames. All right, and then here, this is let's see, this is when they sent over what Ferguson went and grabbed. So yeah, so remember we heard Doug Bates say, oh, I think Boyano for informing me that Kathy Ferguson went and grabbed this hard drive. To whom it may concern, so this is August 23rd, 2024. Farrah Rogers is my legal assistant and is duly authorized to collect any documents from the TBI, other lawyers, agencies, law offices, clerk's offices, and any other similar entities in the official capacity as my assistant. And then this is the order that we looked at. So there's that. Yeah. Where was the circumvention? I don't know. I don't know. All right. State's response to petitioner's motion to issue a writ for the appearance for inmate John Dylan Adams. Why is this wait, they don't want this? Yeah. Please install our potential backdoor software. Petitioner alleges several areas in which his trial counsel erred relative to indicted co-defendant Dylan Adams. It's difficult to decipher exactly what petitioner claims his attorneys did wrong relative to Dylan Adams, but it appears that he is bothered by the fact that his attorneys did not call Dylan Adams as a witness and or do more to establish Dylan Adams' innocence. Well, I'm bothered by that too. Because, like, shouldn't anybody be bothered by somebody not doing enough to establish, and it's not really their client, but when your client is accused of doing something with somebody else and there's things that could show misconduct relating to how either were approached during the course of the investigation, fighting for the innocence of Dylan Adams would necessarily, it would be a carryover fight for Zach Adams' innocence. The state submits that the issues before this court pertain to Zach Adams and whether he was denied the assistance of counsel that our Constitution promises him. At the time petitioner chose to exercise his right to a trial by jury, Dylan Adams was an indicted co-defendant whose charges were pending, and you fought to have him severed. You wanted to try them separately. Consequently, Dylan Adams enjoyed the benefits, privileges, and protections of the Fifth Amendment. He was represented by counsel, one whom under no circumstances would have sat silently had petitioner's trial attorneys, quote, called Dylan Adams to the stand. One whom under no circumstances would have allowed his client, Dylan Adams, to take the stand. Well, you know what? Couldn't you have just let Dylan Adams go live with a private investigator for Zach Adams' team and, like, balance the scale? Forget testimony at trial. Like, Zach could have had a constitutionally fair trial if his co-defendants were forced to go live with one of his own investigators. Like, maybe we've had a different outcome here. So, yeah, without one-on-one discussion about the possible consequences of testifying for the petitioner. Additionally, petitioner's trial attorneys understood they could not speak to Dylan Adams without going through his attorney. For the sake of this response, one must hypothesize that petitioner requests Dylan Adams' appearance before this court to offer an alibi for the petitioner. It belies reason to argue that if Zach Adams had an alibi, his dogged, relentless, tireless attorneys chose to ignore it. Had Dylan Adams been able to credibly alibi his brother, the state submits petitioner would have never been charged, much less convicted. Yeah, we didn't choose to ignore it. We just couldn't get John Marshall Walker in. So, like, the state knows this stuff and they're ignoring it. Petitioner perhaps hopes to present Dylan Adams' testimony to continue this false narrative about the, quote, new ATM video. Again, as the state has previously mentioned, there is no new ATM video. The ATM video that petitioner and his attorneys reference was provided to petitioner's trial attorneys on June 19th, 2015. I still have issues with this, and I can't wait. I have not gone and re-listened to Doug's opening. We're going to do it on Sunday. But there is something that Doug said, because when we first started watching this, I thought Doug was going to point to Terry Dykes and throw Terry Dykes under the bus well, not really throwing him under the bus, but saying that Terry Dykes did something wrong with this video footage. Because he mentions Terry Dykes seemingly saw more. And we learn as we piece more details together. I did not follow it fully when we first watched Doug Bates' opening arguments in November. But now I'm getting it. Terry Dykes looked at something very early on, and it was a moving video. It was a longer span of time. He got to see the whole thing. And then it seems like now what's actually in that discovery folder is like a piecemeal, frame by frame by frame by frame, cut to certain timestamps. And again, that could have very well been the reason why the state panicked when the defense wanted to go get the ATM machine themselves. So, did Dykus have more available to him? Even if he didn't fully connect the dot at the time of? Because it seems like Dykus's description and recollection and reports and how he proceeded with his investigation referenced something that was more comprehensive than what is available in this discovery 8-step folder to access. I wouldn't wish that on Katie, but also hilarious. Sheriff Chuck says, I think they should let Autry be under house arrest with Dr. Spiro. Oh my goodness. They'd be like, they would have such a problem. Just imagine if the state was in a position to be confronted with, hey, we had a witness that was saying things that didn't help the state. We made them live with our private investigator, and now they want to incriminate. I mean, now they want to point to a third-party culprit. They don't want to cooperate with you anymore. The state would lose their mind. The state would lose their mind. Which, again, maybe they should. Like, having someone live with a witness can taint their testimony, can taint their recollection. But again, it's the hypocrisy. It's the fact that the state gets to do whatever they want, and we're supposed to trust the outcome of it. So we've got, they possessed every second of every bit of footage gathered in this case long before jury selection began. I'm not sure about that. The state would not be surprised that petitioners' attorneys possessed a video footage that the state did not and does not currently possess. Well, and again, was that your concern about running down and getting that ATM hardware, having Kathy Ferguson go in 2024? Petitioners' trial attorneys are provided countless hours of video footage through discovery. Additionally, petitioners' attorneys, on their own, issued subpoenas for video footage from the bank's ATM and other businesses around the bank. Again, it's likely that petitioners' attorneys, at the time of trial, had even more footage from the area than the state did. But you guys just said in another filing, we just looked at it. You guys acknowledged that when Jennifer Thompson tried to get information from the bank before it was renamed, they looked for like an hour, and they were like, we don't have anything for that. So the state is making this argument. At the time of trial, they probably had more than we did, when the state didn't even want to provide Jennifer Thompson with something that the state had available. But given that no proof was presented regarding any of it from the defense, the video footage was not and is not exculpatory. It did not and does not help petitioner's claim of innocence. Consequently, it is irrelevant to a claim of ineffective assistance of counsel. Not only does the state know it was given to petitioner's attorneys, oh my God, if I was reading this, I would be so pissed. And this is what, March? So this is before we have the hearings. I can see 100,000,000% why Doug Bates was up there with the righteous indignation he had when we watch his opening statements. Oh my goodness. So petitioner's attorney's files contained communications about the video. So the state knows it was given, as it's been in Mr. Bates' possession since his representation began, but there were communications about the video. Petitioners continued attempts at characterizing this video as either something new or something no one took the time to view are disingenuous at best. Oh, I think someone took time to view it. I think Terry Dykus did. And I think something funny has happened since. And you kicked him out so he wouldn't hopefully be able to tell the jury about it. Petitioner's dogged, tireless, and relentless trial attorneys did not pursue either the ATM video or using Dylan Adams as a witness, because to do so would have either made the state's case even stronger or been intellectually inconsistent with the defense they presented. Again, petitioner's current attorneys have the ATM video. They have had it since they started representing petitioner and gained access to the state's files and the files of Ms. Thompson and Mr. Simmons. The video establishes nothing beyond a truck is at an ATM at 11:12 a.m. the morning Holly Boba was kidnapped, raped, and murdered. To claim that it casts doubt on petitioner's guilt is to ignore every single piece of testimony and evidence in the case. Well, that's typically how an alibi works. If somebody's somewhere else, where it would be impossible for them to be somewhere that is necessary for the state's timeline to make sense, yeah, then that alibi necessarily, and the jury can decide to ignore every other single piece of testimony and evidence in this case. But the problem is they need that alibi presented competently for that to even be an option, for that to even be a pathway in deliberations. Any testimony from Dylan Adams on this case is irrelevant to the issues before this court. Petitioner also alleges that his trial attorneys failed to call a handwriting expert to show that Dylan Adams' written statement was fraudulently obtained. The state does not know what this is in reference to. You don't? You don't? Dylan Adams did not provide a handwritten statement in this case. I mean, I'm going to say true. True. The handwriting that petitioner may be referencing is the handwriting of the TBI agent who interviewed Dylan Adams on several occasions, resulting in several statements from Dylan Adams, but none of them was written by Dylan Adams. The practice followed by TBI in all cases is that the agent writes a statement in the first person as if the person being interviewed is writing. Wasn't that an investigative report? We should rewatch that too. Dylan Adams on the stand. Wasn't it something more like it was an investigative report that was written in the first person? The statement is reviewed by the person being interviewed. They can make corrections to the statement, and those corrections are initialed. In fact, Dylan Adams did that in this case. The person being interviewed then signs a statement. Dylan Adams' statement was taken in this matter and adopted by him and signed by him. Dylan Adams, on a separate occasion, gave a statement that was video recorded. At the time of Dylan Adams' statement, TBI prohibited the recording of statements, of course, unless it was an extreme circumstance and a supervisor approved. Dylan Adams' statement met those criteria. They needed it on record because they were struggling to get him to say these things otherwise. Oh my goodness. It belies logic to accuse petitioner's attorneys of not calling a witness to opine about something that does not exist. And in any case, I think that they were talking about a letter that was supposedly written to the Benjamins. Right? I think they're conflating two things. There was like an IR that was written in the first person, but then there was also supposed to be like this handwritten sort of love letter to the Benjamins, like, I loved living with you so much. You guys would never do anything weird while I was living there, like try to like feed me information and get me to admit to certain things. I loved my time with you. Good times. Can't wait to hang out again. Like, I think it's two different things that they're conflating there. And I'm pretty sure they're well aware of both, but they're going to feign confusion here for the point of this motion. So for the foregoing reasons, petitioner's motion to issue a writ of appearance for John Dylan Adams should be denied. So we don't want Dylan to come clear this up. Why do you want this denied if you think Attorney Bates is stepping on a rake with this? If you think it belies logic, why wouldn't you want Dylan Adams to just come shut down whatever the defense is trying to tell the court, argue to the court? I don't really think that's a good reason to say Dylan Adams shouldn't be allowed to testify. Bring him. Bring him. And then they did. And he identifies himself in Parsons making a purchase, corroborating the same time frame as his ATM video, and then before they go to the Sonic. Chat. Shout out GB, thank you for the 5, says my self-serving alibi. I know, that's such a good phrase, right? Like, what alibi isn't self-serving? I just love it. It's just pure salt that they added in self-serving alibi. And thank you for the super. Oh my goodness. All right, the one we're on is called what? Response for the writ. Okay. All right, so this one, all right, this one's 3 pages and there's 3 more for March. So let's try to get this. We're going to do a 3 o'clock time limit on this one. I won't end in the middle of a motion, but I won't start a new one after 3. That's my rule for myself today. I've got to assemble a desk. Ever since I replaced a second monitor and it's a different size, I've been like really nervous about how my 2 monitors sit. Like one is like half leaning off the desk because it's not as deep as it needs to be. So I gotta put the other desk together, unplug everything, swap the desk, replug everything in. And I love good cable management, but I hate I hate practicing good cable management. So I don't want to put that off. I think I'm going to do that after this stream. So I've got to commit to giving myself some free time tonight. All right, so we've got this here. Comes now the state of Tennessee by and through the undersigned attorneys and in response to petitioner's motion for a court order approving communication with Jason Autry. So we don't want you to communicate with Jason Autry, because the state has filed a motion requesting this court first appoint counsel to represent inmate Autry, and we're incorporating those arguments. If that motion is granted and said counsel, after meeting with inmate Autry, relays that inmate Autry wishes to waive his rights and testify for the petitioner, then petitioner attorneys can confer with, meet with, and interview Autry. 3, petitioner fails to outline any potential harm to petitioner's case or the duty of this court in simply sending an independent, objective, unbiased attorney to have the initial contact and discussion with inmate Autry. For the foregoing reasons, the state requests said motion be denied. All right, next one. All right, state's response to petitioner's motion to compel the state to comply with Rule 28. So this court's order on January 16th, which was entered on February 3rd, renders this issue moot. So no need to grant or deny that. I think that was a repeat. Didn't they already do that? Yeah, I have a separate one that we read on March 7th for that. So maybe they filed that twice. Or maybe it got uploaded twice. Next one. Well, let me close all my tabs. Every 5 motions, I need a reminder to close my tabs of the ones that we've already read. Okay, so state's response to petitioner's motion to determine validity of state's discovery Rule 16 obligations. So comes now the state of Tennessee. Through the undersigned attorneys and in response to the above captioned motion submits the following. The state's fully aware of discovery. We know the rules. We know the rules. I don't have a rule book in front of me, Mr. Bates. Petitioner alleges that said statutes and rules require the state to provide the petitioner with all documents that were not in Jennifer Thompson or Jim Simmons' file that the state has reviewed. What petitioner requests is beyond the mandates of Tennessee law. Oh, so now you know when things are overbroad. The state of Tennessee submits that what is required by Tennessee law is the following as set forth in Frazier v. State. Like, every motion that the response that they're filing now is something that the defense attorneys have had to address already in the opposite direction. Oh, my laptop does that too, EJF. Like the fan gets really loud if I have too many tabs open. Yes, Sheriff Chuck says, so the state wants to force Autry to get an attorney to defend the state's position. Yep. Although I would love to hear Jason Autry get on the stand and go, I plead the fifth. Like, I can hear it. Those items deemed discoverable under Rule 16, if relevant to the issues raised in the post-conviction petition, that's what it should be limited to, and any other disclosures required by state or federal constitutions. They say, though not required, the state, as petitioner's attorney set forth in their motion, invited counsel to view the entire investigative and trial materials housed at the offices of District Attorney Ray Whitley in Sumner County. Per petitioner's filing, they have not accepted said offer. Our duties under Rule 16 are ongoing. All right, nice and quick. All right, we've got 2 more for March. Oh God, 25 pages. Oh my God. Wait. State's response in opposition to petitioner's motion to quash. How long did it take them? Because we read the motion to quash from Turin. Okay, so the petitioner to quash Dr. Katie Spiro's subpoena from... Let's see. That was March 7th. And then Turin's motion to quash was March 11th. So this one's just responding to the petitioner's motion. And they're going to cite the code here that, who's actually exempt. State subpoenas ducis tecum for materials in Dr. Spiro's possession is a pretrial production subpoena, so that statute's not applicable. Let's see. Petitioner Adams and Dr. Spiro have continuously engaged in subterfuge and misdirection with this court regarding Dr. Spiro's involvement in this case. The state subpoenaed Dr. Spiro in the first place because Attorney Bates represented to the state and this court on multiple occasions that he severed his attorney/investigator relationship with Dr. Spiro on or about February 11th, 2024. Furthermore, the reason provided by Attorney Bates to the state and this court for severing his professional relationship with Spiro was that, and this is all the way emphasized, Dr. Spiro, acting as Attorney Bates' agent, intended to engage in conduct that would violate the rules of professional conduct for a licensed attorney in Tennessee, with a footnote that says, it appears from Petitioner Adams' motion to quash Dr. Katie Spiro's subpoena that Attorney Bates did not end his attorney/investigator relationship with Dr. Spiro as previously represented to this court. Attorney Bates contends that Petitioner Adams has standing to sit under the protection of 2 of the 3 umbrellas Dr. Spiro's work employs. No, he gave different date ranges. You guys remember the umbrella arguments. He was like, for what this would cover during this time period versus what this wouldn't cover during that time period. They're just going to ignore that. So, let's see. Attorney Bates contends that Petitioner Adams has standing to sit under the protection of the 2 of 3 umbrellas Dr. Spiro's work employs, being first as Dr. Spiro was his attorney's agent from the late Sumner fall 2023 when work began on this counsel with counsel's appointment. The state suspects that Dr. Spiro's professional relationship with Attorney Bates did not end in February 2024, but has continued uninterrupted through this litigation. All right, let's see what they say to argue that. So we were here. Dr. Spiro was brought into this case by Attorney Bates as a clinical neuropsychologist expert. Petitioner Adams' post-conviction pleadings are replete with references to Dr. Katie Spiro's work and involvement in this post-conviction matter. Well, yeah, because he probably wanted her to come on and initially opine on why somebody might give a false testimony, false confession, plea falsely. But then she's willing to go investigate things on behalf of Cindy Adams. That's a different story. And again, I think it's really endearing to Katie's credibility that she has other clients that the counsel that hired her and the client and or the client were like, dang, you're not saying what we want you to say at all. What if Cindy Adams, this was the first time she had someone say, like, this is someone besides an attorney that's appointed through these procedures that's like out here on the open having questions about my son's conviction and said, I want to talk to you more, Katie. And then something blossomed from there. So on January 20, and I'm still thinking of, there's that subpoena for Cindy Adams sitting on this docket during this time period. So on January 22nd, 2024, Petitioner Adams filed a sworn affidavit of Dr. Spiro, including her CV, with this court that laid out a detailed description of Dr. Spiro's professional credentials, summation of her interviews with numerous witnesses involved with this matter, and conclusion based on her investigation. Oh, I would love that. I would love like a detailed report, not the affidavit that we read. Imagine a full report from Katie Spiro. Upon information and belief, Dr. Spiro video recorded her interview with Petitioner Adams on December 1st, 2023 in the Tennessee Department of Corrections. And this is an OCR, but I wish I could just search for the name Cindy. Upon information and belief, partial footage of this interview was broadcast by ABC News 2020 on May 31st, 2024. On December 15th, Attorney Bates' office emailed the visitation. We went through all of this. They're going to spell the same thing out again. The emails, let's see. All right, January 30th, when Attorney Bates emails Morgan County Correctional to set up a follow-up meeting. And they're emphasizing here from the in-person evaluation with offender Zachary Adams on January 31st at 1 p.m. On April 1st, Dr. Katie Spiro, in an email attempting to schedule a Zoom meeting with Petitioner Adams, represented that she was Dr. Katie Spiro. This is the April 1st one that we looked at. I think this one's different. Let's look at C. I don't know if I remember that. So, January 31st, all these required attendees, meeting status, meeting organizer. Attorney Bates is requesting a legal call with Dr. Spiro for a follow-up phone call from the in-person evaluation with the offender on January 31st at 1 p.m. Eastern. Please have offender Adams to Team 2 Hub for this call. And then they're coordinating time. I can't schedule between 10 and 12. I have to be there before 3. And then, hi, Miss Wright. Dr. Spiro would like to speak with Zachary Adams on January 31st. Dr. Spiro, let's see. This is the one we saw. This is a different exhibit now. So that's the April 1st one. So that was a new email, but I mean, I don't see anything important about it. That's January 31st. So, where were we? Where did they say Exhibit C? So yeah. April 31st, she's emailing on her own. On April 5th, that's when Katie Spiro introduces herself. Wouldn't these things support that she's not doing things on Doug's behalf, since now the emails are coming from Katie herself in April? So in January, Doug's sending the email. In April, Katie's sending the email. On April 8th, 2024, Dr. Spiro attempted to schedule another meeting with inmate Autry at the federal holding at the Shelby County Division of Corrections Visitation Office. She did this via an email on which attorney Dana McClendon was copied. Are they going to say that, like, Dana was talking to Doug? And then whatever Doug was saying to Dana was telling to Katie or something? This is the notary question. On May 31st, ABC News airs that episode with the Zach Adams coverage. Katie Spiro appears in it. Dr. Katie Spiro has repeatedly represented herself to this court, Department of Corrections, and the Shelby County Division of Corrections Visitation Office as a forensic and clinical neuropsychologist. As an expert in forensic and clinical neuropsychology, Dr. Spiro uses her professional credentials to get in the door, the sword, and then claims investigator journalist privilege as a shield in an attempt to circumvent the rules on experts in litigation. Well, I mean, again, just stick to the media argument and how that doesn't apply. But I don't get... Okay, so as of January 22nd, 2024, Petitioner Adams affirmatively relied upon Dr. Spiro's work, opinions, and conclusions through his pleadings with this court, making Dr. Spiro an expert witness. Under Rule 16, a defense expert must turn over certain materials to the state if the defense has requested and received similar materials from the state. So again, there's different interviews that Katie has done, and they're saying, hey, Doug has written to TDOC sometimes, but they're not tying anything that Doug has initiated with the thing that they're taking issue with, like what's ultimately aired by 2020. They say specifically the defense must permit the state to inspect and copy or photograph, like everything that they tried to subpoena. All books, photographs, documents, tangible objects, copies that are in the defendant's possession, custody, or control, and that the defendant intends to introduce the items as evidence in the defendant's case in chief at trial. Any results or reports of physical or mental examinations and of specific tests or experiments made in connection with a particular case or copies thereof. And then, or anything that the defendant calls to introduce as a witness at the trial who prepared the report, and the results or reports relate to the witness's testimony. So now they're going to address the argument. I mean, I don't see, again, how does this, if Zach Adams, like, I don't remember the exact date, but for example, there's a little snippet where he's talking about driving backwards through the ATM. I mean, the state would have us convinced with their arguments here, if we took it at face value, that was some type of psychological evaluation and it's expert testimony that the parties need to disclose to us. But it wasn't. Yeah, and this is all about this video, this recanting video. GB says 2 words, 1 Dennis, 2 Benjamin. Sheriff Chuck says the state is used to using one person to talk to another to hide what they are doing. They assume everyone else operates that way. Yeah, the Dinsmore, Booth, Nichols, Benjamin pipeline. Autry, got to put Autry in there. Let's see. So Petitioner Adams argues that 16b2 limits disclosure of items requested by the state in its subpoena on Dr. Spiro because of the following. Except as to scientific or medical reports, this subdivision does not authorize the discovery of reports or memorandum or internal defense documents. A statement made by the defendant to the defendant's agents or attorneys, or statement by actual or prospective state or defense witness made to the defendant or the defendant's agents or attorneys. They made a layered argument. Like, I also don't like that we're saying that the petitioner made a blanket argument, because they said there were different umbrellas, and that where one might apply, another might not. Dr. Spiro, a licensed forensic and clinical neuropsychologist, has interviewed various witnesses involved in this litigation as a forensic and clinical neuropsychologist, and submitted her opinions and conclusions about those witnesses in a sworn declaration filed with this court. As such, Dr. Spiro's work product should be considered as a scientific or medical report exception. But again, when and who was that work done for? And how do you distinguish that from what she might have been doing for Cindy Adams? Totally unrelated to anything that Doug Bates or Zach Adams was employing her to do as an agent for anything relative to this petition. They just want it all to be in the same. Oh, I like this. A saying from my language: a thief thinks everybody steals. So Dr. Spiro cannot be allowed to circumvent these laws and make a mockery of our established criminal procedure. As set forth above, Rule 16 clearly establishes a procedure that allows the opposing counsel to review materials used by an expert to reach their conclusion. Experts are assumed to be professionals, unbiased, who work for the good of their profession. Dr. Spiro's ongoing gamesmanship in this matter is contrary to the administration of justice, and unless stopped, a precedent could be allowing defendants going forward to hire an expert and then have that expert claim they are an investigator, reporter, etc. to sidestep the rules. She wants me to put the flames up, but I'm not gonna do it. I'm just gonna do the flailing. I'm gonna get some flailing going on. Wherefore, premises considered, the state of Tennessee would respectfully request this honorable court deny Petitioner Adams' motion to quash Dr. Katie Spiro's subpoena. Order that Spiro produce all items set forth, all of them. Alternatively, order that Spiro produce all items for an in-camera review so that this court can decide, and then for any other relief. So, and quick, we got to go to the last March one before my time limit hits. This is the last one for March, guys. We're going to do it. 3 minutes to spare. We got it up. We're good. So, yeah, there's been some fun in these motions. There's been some really frustrating parts, but you know, I think, like, imagine reading these as they were happening, and not knowing, like, what's going to happen next. Like, are they going to be able to do these things at these hearings? Are these hearings going to continue through December? So, all right. So this is just a response to, you know, we need, just write this 10-point letter and tell the Department of Corrections, tell Kentucky to get Jason Autry over here. We need him for like a day. We just need him for a day. And the state doesn't want to do it because he's too dangerous to transport. So they respond. They say, the state of Tennessee refuses to be involved in Petitioner Adams and Dr. Spiro's continuous attempts to subordinate perjury with Jason Autry. Now, this is the unwarranted indignation. This is puffing your chest out. You are going to presume now, because you're personally offended, you feel called out for something that, yeah, all signs seem to point to you doing. You got to puff your chest out in this motion and say, they're attempting to subordinate perjury. Subordinate perjury. Subordinate. As previously set forth in the state's motion requesting the court to appoint counsel for Jason Autry, the state is aware through recorded jail calls of 3 statements made by inmate Autry in reference to this recorded conversation with Dr. Spiro. And is this repetitious, or did I just open the wrong one? Wait, this is the one without a date. Hold on, did I open the wrong document? No, they're just repeating themselves. Okay, so they're just going to repeat this. So this is where we have the Skylar Pinkley thing. They're going to put this transcript in there. This is from January 3rd, 2024, where he's saying he was high on drugs, meeting with Spiro. And then inmate Autry advised his mother on January 31st, they're going to fuck me in federal court. I'm fucking them in state court. Furthermore, transporting Jason Autry poses a high security risk for law enforcement, which includes but is not limited to 1, the lengthy criminal history, and an attempted escape conviction. 3, we're getting the gang affiliations on paper here. We've got that mentioned. 4, a lengthy prison disciplinary history. 5, serious medical issues. And 6, was attacked and seriously injured by other inmates over the last 12 months. Can we narrow that down a little bit? When was he attacked? Can we narrow this down? This court is the distiller of truth. Our job as state prosecutors is unique among licensed attorneys. We have a duty to bring all sides to the court. But we are not asked to put on blinders. The state is aware, and now the court is also aware, of the trickery, deceit, and subterfuge that has been in play from day one by Petitioner Adams and Dr. Spiro. There is not an iota of substance to Dr. Spiro's recorded conversation with Jason Autry on December 22nd, 2023. To go along with Petitioner Adams' request to make the state of Tennessee responsible for Jason Autry and get his witness here under these circumstances would defy the very oath we took as protectors. So now Jason Autry is not our witness. Wherefore, premises considered, the state of Tennessee would respectfully request that this honorable court deny Petitioner Adams' motion to compel the state of Tennessee to issue a 10-point letter containing the prosecutor's certification concerning Jason Autry, and 2, for any general or specific relief the state of Tennessee is entitled to. Objection cumulative. Yeah, GV says I was waiting for this. Just put the star witness on the stand. That is crazy. Like, the emphasis. And if you're not looking at the screen, they capitalized and bolded his witness. Jury of 12 peers. Oh god, we're going to hear a lot of her yelling on Monday because she's going to be calling her witnesses. We're going to have Boat Guy. We're going to have Boat Guy take the stand. She's going to have to deliver a closing argument when the evidentiary closes. We're going to hear a lot of Amy Wyrick screaming on Monday and Tuesday, so be ready, guys. Be prepared. Go watch that song from The Lion King. Get in the spirit, or the anti-spirit, of Amy Wyrick. Just going to be a good time. So guys, that wraps us up with the March stuff. So we're going to have counsel appointed for Autry. We're going to have some orders come down. And we're going to get through all of this stuff. The docket, the last thing available on the media page that they had with all these filings, was this July 1st order denying petitioner's sealed motion to unseal of Michael Scholl. I couldn't read this order, but you can kind of ascertain from the title what it was. But this is what we'll be going through tomorrow. We'll get together and we'll pound through this docket. Hopefully none of these are like 900 pages long. We're going to get it done. Also, shout out to Christy. Christy sent over all the volumes of the transcripts. So maybe that's what we can do on Sunday. We've got so much still, I feel like. We've looked through so much. We've really done a deep dive. We've got a little more to try to squeeze in before Monday and Tuesday. And of course, there might be a time gap between the close of the hearing on the 30th and when the judge actually issues his decision. So we keep looking at things. But I'm excited. I really think that we should get through these and then look at some of the sidebar transcripts before Monday. So yeah, just a light read. And Christy, I think what we're going to do, Kay Riggs had me thinking about it, was just using certain language, like when they put in parentheses and where a conference at the bench was held. We can search for all of those and just jump to all the sidebars. So yeah, Bailey's, me too. I keep forgetting that today is Friday and not Sunday. And the same thing's going to happen next year with like the New Year's holiday next week. The New Year's holiday. I'm going to like be lost on what day of the week it is. But yeah, so we've got Saturday and Sunday. And don't forget, we have some guy with cancer's birthday tomorrow. We have Adventure Aaron's birthday on Sunday. And then we've got the hearings on Monday and Tuesday. So we will not be reading the trial transcripts in full, but we will skip to those parts where there are sidebars. And also we'll read all of jury instructions. So yes, yesterday was Sunday. That's going to confuse anybody that watches this like a week from now. Today is the day after Christmas, folks. Yeah, Trikisha says it feels like a Saturday even though I'm working. Oh no. Court TV says they'll be streaming. So, and I assume that Law and Crime will also syndicate a stream. So, oh, that's awesome. So 12:30 is Marcellus's birthday too. Wouldn't that be like, I don't know. I feel like if justice is screamed out in the court on the 30th, it'll reverberate a little bit for Marcellus Williams as well. So you guys, I don't know who's doing what today. It is Friday. It's 3 p.m. Eastern. I don't know who's got a live scheduled. I don't know if everybody's doing their regular routine as far as like where we can redirect to. Let me see who pops up. Everybody has upcoming streams. It's nap time. Is Dolly live? I don't see him. Let me type his name. I typed Dolly Talk and it's showing me my own stream. Probably because I said his name out loud. Oh, or maybe because he's linked in the description. Let me get the direct link to his live, you guys, and see if it'll let me plug it in. Okay. Dolly Talk. Wait, I don't see him live. Oh, okay, it was a premiere. Okay, yeah, I can't do that. All right, who else? Does anyone have anything premiering? Okay, Take It to Trial has something. I think it's alive. I think it's alive, but it might be a premiere since it wasn't coming up. But she's starting in 30 minutes, well, 20 minutes. It looks like she's going to be going through opening statements and the Autry recanting. So she's not live now, but she'll hit the notify button and it'll pop up when she goes live. We'll go over there. Yeah. Dolly, my homie. But yeah, so there we go, guys. Let's wrap that up. Everybody enjoy your Friday afternoon or whatever it feels like to you. We'll get back together. I don't think I'll be able to pop back on tonight, but tomorrow we're going to finish this April through that July 1st thing that we can't open. And also maybe look at the 2010 audit and you know, civil forfeiture funds and fun times in the judicial district where this was all happening. So I think that's on the menu for tomorrow. We'll do Doug Bates opening statements and sidebar transcript Sunday. I think that's what we'll do. So everyone take care. Heck yeah, Mel says, see y'all tomorrow after the movies. Enjoy your movie time. Trikisha, have a good rest of your day at work. Hope it ends quickly. Yeah, destined to be, everyone's retired today. Nobody wanted to go live. So it's very odd. It feels very out of place. All right, you guys, see you next time. Love and appreciate all of you. Thank you also for all of the gift giving. We had Sheriff Chuck and we had Autry's fake accent and we had Jay Money dropping like 1 million gifts in the chat. So big thank you to you guys making everyone green, growing the gang. See you guys somewhere else later or tomorrow. Bye, guys.